I'm calling to order the Tuesday, October 1st, 2013 meeting of the Township of South Orange Village Board of Adjustment. May we have a roll call?
Yes, Mr. Don.
Here.
Mr. DeScalo.
Here.
Mr. Groman. Mr. Polipiano.
Here.
Mr. Reeves.
Here.
Mr. Semper.
Here.
Mr. Adler.
Here.
Mr. Shapiro.
Here.
And Ms. Warren.
Here.
Pursuant to Section 5, Chapter 231, PL 1975, this is to state for the record that adequate notice of this meeting has been provided to the public by posting and maintaining the annual notice of regular meetings on the bulletin board in Village Hall, by publishing the annual notice of regular meetings for 2013 in the December 2012 edition of the South Orange Maplewood News Record, and by filing said notice in the office of the village clerk. Okay, so the first order of business tonight is the approval of minutes of the regular meeting held on Tuesday, September 3rd. And I guess I should add that this is our first meeting at SOPAC, and we'll be here for the next number of months through when?
May?
I think at least through April, May,
No, we're going to probably be here well over a year.
for over a year?
Yes.
Okay, all right. So thank everybody for making it here. The minutes for Tuesday, September 3rd, we have those, and I don't think there was too much to be said. We've changed mythology to methodology. And is there anything else there? I think that was pretty much it. Do we have any comments about the minutes?
I move that we accept them with
And I'll second.
methodology.
May we have a second?
I have a second.
Okay, Mr. Don.
Yes.
Mr. DeScalo.
Yes.
Mr. Polipiano.
Yes.
Mr. Reeves.
Yes.
Mr. Semper.
Yes.
Mr. Adler.
Abstain.
Mr. Shapiro.
Abstain.
And Ms. Warren.
Yes.
Okay. And the next order of business is the revote on case 1002 LOJ Properties at 301 South Orange Avenue.
Mr. Chairman, I'm going to duck out for that one.
Okay.
Okay.
You know, okay, he could sit there, couldn't?
Don't talk too far.
Let's go.
Can you remind us who
Yes.
made the motion?
Let us, do we have anybody here who represents that applicant? Nobody here? Okay, so for the benefit of the public and for reminding for ourselves, this is actually unprecedented case where we took a vote on this, and it was a 4-3 vote. Oh, there's Mr. Friedland. Hi, Mr. Friedland.
Good evening. I couldn't find this place. That's the reason I'm a little bit late.
Perfect
I'm
time.
looking for my client. I don't see her, but am I ready?
Well, we're ready. Yes, we're just beginning it right now. Did you?
I'll wait till you're,
Well, we're ready to go.
okay.
So come on up.
He's on his way.
It's a rather different environment, I'll say that much. May I?
Yeah, please.
Thank you, Mr. Chairman. We're seeking reconsideration of the application previously heard on May 7th and July 2nd. The applicant and 2 expert witnesses testified and submitted considerable plans and drawings to convert an existing rear office into a clerical office for use in their occupational therapy business. A D variance was sought, given the fact that offices are not permitted in an RA 60 zone. Notice was published in the South Orange Maplewood News Record on September the 12th, and I have an affidavit of publication provided on September the 12th. Does the board have that?
I believe we probably.
I mean, I have it. Do you want me? Should I give it to you? All right, we'll do it later. The notice to the property owners was duly sent by certified mail. All return receipts were signed, save for 4 undeliverable envelopes that I just received today in my office. The resolution of your board memorialized the June 25th, 13 motion to approve our application, and it was denied. 4 votes in favor, 3 votes against, 5 affirmative votes were required for a D variance, hence it was denied. The last page of the resolution sets forth the action taken by the board. And why are we here, or why am I here? Because the reconsideration was based upon a board member who may have had a conflict of interest and shouldn't have cast his vote. Under Rule 2.9-1, the model rules for Zoning Board of Adjustment of the land use law, any applicant or other interested person may, within 20 days after publication of notice of decision, move the board for a rehearing by filing application in the form of a letter addressed to the board containing a brief statement of the grounds relied on. The board may grant a rehearing on its own motion, and this is based upon, according to the rule, mistake or fraud in the proceedings is an exception. So I really am not privy to exactly what took place with respect to the board member who indicated either to counsel or to Dr. Reeves that there was a conflict. However, I'm here and we've re-noticed it, and hopefully we'll get a favorable vote this evening.
Okay, thank you. This is unprecedented for this board. This is unprecedented for this board in this procedure. Can you hear me?
Yeah, I can now.
Okay. All right. As I understand it, and you can help me out, Mr. Dwyer, here, the procedure here tonight is, since Mr. Adler is the one who has recused himself, that we have the next alternate vote who attended the hearings, and that was Ms. Wern, that the other votes remain the same. Or does everybody re-vote?
It basically is a reopening of the application, and this was not done pursuant to the model rules because we did not adopt the model rules. This is something the board has taken on its own accord, having recognized the potential problem, having been advised post-vote that there was a potential conflict. The board has on its own decided to re-vote, and those people who voted for or against, because this is a hearing, in effect, the case is the transcript that was produced from the hearings that when we were heard in May and June. That's the case. I doubt if there's anybody else here to add anything more to that other than what Mr. Friedland said, but people are free to vote as they would as if it were the end of any other case at this point. The evidence being what was the evidence initially. The only difference being it'll be a different person, different people voting. I would say that if there are 7 regular members here, each of whom is qualified, that those 7 regular members would vote. If they weren't at a meeting and they certified that they would be the people voting. If any of those are absent, then first alternate and then second alternate.
Okay. So, again, does that mean that we all re-vote?
Yes.
Okay. All right.
I noticed that we only have 7 this evening, is that right? Or am I not counting properly?
1, 2, 3, 4, 5, 6, 7.
Now we have 7.
Mr. Groman is not here,
No, Mr. Groman's
and
not.
he didn't cast a vote.
He didn't vote in any case.
He attended the first meeting, but he did not attend the second.
Yes.
So at that point, we had a 4-3 loss.
Yes.
So hopefully we'll have a 5-2 determination this evening.
Okay. So,
So based on the testimony and the evidence produced during the hearing when this board heard the matter, Does anyone want to make a motion or discuss the application?
I'll make the motion to approve, as I did previously.
Second.
Okay, and the motion was, as it's written, was to approve the application. So your motion is to approve the application.
Correct.
To approve the variance application.
Right, okay.
So a vote in favor would be a vote in favor of the variance.
I mean, is it possible to hear what our previous votes were? Like, for some reason I don't even recall that Mr. Don was the one that made the motion on this.
Mrs. Semper made the motion.
And I seconded it.
Mrs. Semper made the motion, and Mr. Don seconded. And then Mrs. Descala, Mr. Parley Piano, Mr. Semper, and Mr. Shapiro voted for it, and Mr. Aller, well, Mr.
No.
Wait.
As I recall, Mr. Don voted for it, Mr. Semper voted for it, Mr. Shapiro voted for it, and Mr. Descala voted for it.
Yes, you, Michael, and
Are you running down the aye votes right now?
Yes.
Okay.
Previously, right.
Yeah.
Any other conditions on the yes vote?
do we have any conditions in the approval, Patrick, other than the normal ones?
Right, I believe that the applicant had self-imposed a condition to restrict the use to clerical administrative office for a home health care agency.
Yeah, I mean, that was a very carefully worded proposal that was made for approval, and there was a lot of back and forth with the applicant about specific conditions, and I think we spent a long time talking about whether we could, in fact, impose such specific conditions on a D variance that runs with the property, and we got some advice about that. So I certainly think that we should be careful now that everyone's clear on what the resolution is. Right, so can we at least restate those conditions? Right.
Okay.
It wasn't just approve, it was restate, like you're restated.
Yeah, my recollection.
Counsel, are you going to read the proposed conditions into the record?
I'm looking at the
Resolution.
resolution to be sure that I state what was,
Because you may not have stated them, given that
Right.
it was a no, right?
administrative offices for a home health care agency was the self-imposed limitation.
Say that again, I'm sorry.
Administrative offices for a home health care agency.
Correct?
And was there a restriction regarding the amount of square footage that could be used? For,
That was noted on the plans.
Yeah, according to the plans.
There was nothing in the resolution about the size of the space, but I believe it was the plans.
It was noted on the plans.
My recollection of this particular case is that the motion was awkward because it started off in one direction and ended with no conditions. And so, that aside from the one that was just stated by Mr. Don, so.
and I don't know if we can address this, but I was wondering if there was a change in circumstances. I believe that this was presented to us many, many months ago with a representation that the applicant was going to be.
He's not here.
Okay. I don't know if we can discuss this based on the procedure, so you'll let me know, but many, many months ago, it was represented to us that the property owner was going to be listing their property where they lived and an attempt to move in. Are we allowed to know whether or not that is moving forward in that direction now that it's been, I think, about 5 or 6 months?
I'm not sure.
That wasn't a condition.
Yeah, that
that
wasn't-
we
No, it was a
imposed.
condition.
It was certainly discussed, but it wasn't
Right.
imposed. And as I remember, the time frame for moving was not imminent. That was discussed, but it wasn't, I don't think that was ever considered to be a condition of approval.
Not a condition, but just a representation.
Yeah, but I think the time frame for that was years, I think.
So at the time, one of the challenges, I think, for the board was whether we would go this direction or we would allow the applicant to continue renting out the property to students. And what I tried to highlight at that point was that if we look at the neighborhood, there would be a bigger impact to the neighborhood with the entire building being changed, or would we allow for it to be used as an office and the other section for the students? I think that's where we left it before we voted.
There's also, in the resolution, a statement made by the applicant in the facts that she stated she intended to move into the house after her kids graduate from Columbia High School, was what the record said.
Well, that was not a condition.
That was not a condition.
That was an expression of intent perhaps in the future. That was not a condition. There are other conditions, but that wasn't one of them.
That's correct.
So are you saying, in addition to the administrative offices for a home health care agency, the applicant was?
That's clearly a condition.
Were there
To be
any other-
utilized,
you mentioned other
administrative
conditions.
offices for home health care business, yes, I agree.
Are there any other conditions?
What?
Are there any other conditions?
Well, there was discussion that there would only be 3 employees. I'm not sure that was set forth in the resolution that I read, but I have a specific recollection of that.
I have just one more question. I think this is clarification by the board. In our agenda, it indicates that the variance was for apartments in the front and office to the rear, but my recollection is that we were just addressing the rear of the building and not the front of the building.
The application is for a D variance for that back appendage part of the building.
All right, yeah,
And you're right, not the front.
okay.
Do we have other questions, statements? So then I believe
This was a tough case, and I feel like to some extent we've reopened the discussion of this case. So I just want to make 2 points, given that we have reopened it. The first is that council started out by saying this is about an existing rear office being converted to professional office space. That's not true. One of the issues in this case was that the use of that space had been abandoned as an office, has been vacant for a long time. And so what we're being asked to do is to essentially rezone this property for office use after that pre-existing use had been abandoned, and that was an agreed fact in the case. And so I just want to make that point again. I also, I appreciate the point about a kind of defensive vote, saying I don't want this to become, a dorm house and damage the neighborhood. But I have a very hard time, voting in favor of an office in a residential zone so that we can prevent somebody from doing something else. I just find that to be a difficult argument.
That was discussed at the second hearing, but Mr. Semper, do you have a comment?
Yeah, because of the statement, I think one of the things that this board has done pretty well is that for every matter that comes before this board, we actually visit the location, see what's going on. And I believe that we have a difficult time in believing that there would be more than 3 employees. But if time was taken, as I did, to go and actually look at the existing office, you would be surprised to know I've never seen more than 3 employees at the place. And they have been at that location for a pretty long time. And when the matter came before the board, I actually felt the same way, whether they would use more of the space and have more employees. But if you, in fact, I know a little bit more about the place because I visited. No place to park, so I know the applicant gets a ride there because she lives in Maplewood, and she comes to work there. There's one other employee, and there's another. I met one other employee. I've never gone to the place and I've seen more than three
Well, my
employees.
recollection, Mr. Semper, that the testimony from Mrs. Lee indicated that she and her husband actually run the business, of course, but it would be a very rare occasion when both of them were there at the same time. And they have an office manager who lives within walking distance to the facility, and she'd never drive. I don't think she even owns a car.
And I think that's why I'm saying that I think it should be in the hearts and minds of the board that it's never going to be. I've never seen, and I've visited lots of time because that's what we do, visit the property to make sure that I'm very comfortable that in voting for this application, that I don't think there will be overcrowding, there's going to be more people, there's going to be more parking, because that's the way they're operating right now.
Okay, so then let me give you my alternative view, because I voted no on this. This is a use variance, so it has a higher standard.
Dr. Reese, could you speak into the...
This is a use variance. I'm going to try to repeat what I said, because I don't want to, because we've opened it, but I just want to repeat what I said and not say anything new, hopefully. This is a use variance. They want an administrative office in a single-family zone. The reason I don't think it was needed is because there is plenty of administrative space elsewhere in town where it is zoned for it, and even there, we are hearing a application tonight. There was administrative space across the street from this home. So for these people to say this is the only place, they didn't say this, but to say that this somehow is necessary to have the administrative office, that isn't true. Also, I made clear that if they had moved in, they could have applied for a professional office in a residence, in which case I said it would be a stronger application.
But they indicated that they can't even consider that until the youngest child graduates from high school.
That's not our problem.
Well, but...
and then trying to figure out what else was there. I also am concerned about then making half of a space an administrative office, and should they not move in, and they're not bound to, then the next becomes what? A rental? So you've got office and rental on the same floor in a residential zone, and those two uses don't work well together, and that could be a problem too.
May I make a comment, or shouldn't I interrupt you?
If I'm trying to come up with something, remember what else I said.
Okay.
There's probably not much else I said. So go ahead.
There is a wall that separates the front area, which is the residence, where perhaps 4 or 5 Seton Hall students reside, and then you cannot gain access from the office area to the residence area. It's blocked off. There's a wall, so it's a total separation.
And you could also take that wall down. The final thing that I commented on was I think you all, both you and Mr. Dwyer, did a good job of at least articulating a rationale to approve it and making a change in the deed. I just didn't buy this novel legal use. I think if it's not unprecedented, it's rare. We haven't done it on this board. Our planner wasn't aware of it. Mr. Dwyer himself hasn't done this. And I'm not sure it could be enforced, so I'm unwilling to get into these arcane legal devices that I don't think could be upheld. So that's why I voted no.
Those covenants that I suggested in my memorandum several months ago are indeed enforceable. If it's put into the deed and it clearly recites the intent of the applicant and the board, it's enforceable. There's like 2 cases that that have approved that.
I think the chair is making a distinction between whether or not something in the deed's enforceable and whether or not this concept of self-imposed limitations and a variance is enforceable.
Yeah.
But I just want to remind the board that there were some nonconformities about the lot with coverage and setbacks, but none of those are being changed with the application.
So what was going to be the format of enforcing this, if the case, or of recording this? There was going to be a deed from the owner to themselves, signed by the board, or with the order, with our order in there?
I don't believe we made that a condition of, that was not a condition.
Because I think if they do a deed to themselves, self-imposing a restriction, it won't hold up unless there's I think like a recording of our order, actually.
But we didn't include that as a condition of the approval in the resolution.
Gotcha.
In the motion for approval, we didn't
Include
we did
it,
not make that a condition.
that they would make the
Correct.
restriction as part of the land records.
Correct. That was not a,
But the board may want to consider that. It's not unusual for use variances to be recorded.
Okay, I'm now lost. How is this different from what we did? They said they were going to put it in their deed, so what is different than what we?
That's basically the same thing. There will be, if someone searches the records for the property, it'll show up that there is a variance that's been granted for that back space, but it's for a specific use and it's limited use, and that will show up in a land search.
But the form of the deed would need to include our order, because otherwise a document from someone to themselves, all the interests collapse into each other.
They can refer to the order.
Yeah.
Just out of curiosity, we had a condition on the resolution that said it for administrative office use only, right? In terms of what uses fall into that, certainly we understand what the applicant's looking to use it for, but would something like a call center be considered an administrative use?
Actually, he proposed administrative offices for a home health care agency.
Okay.
Yeah, it was, effectively, this is zoning for one buyer for one use. That's what this is, right? And the day this property sells and a new buyer buys it, and they don't operate a home health care business with a small administrative office, we're going to have an empty office space in the back, and we're going to have a case in front of us with a new owner saying, give me a spot approval for my office, because you did it before.
With all due respect, I don't agree with that. If in fact, in 4 years, they contract with me to purchase the building with a land use contingency, and I want to use it for X instead of Y, I got to go before the board again.
Well, you could make the same argument about the current buyers who bought it when the use had been abandoned and it was a single-family residential property.
Well, I think we exhausted that discussion, and I think Mr. Keller set forth a very logical and explanatory way of dealing with that issue. I'm not an expert. I can only give you advisory comments.
I would like to move this forward to a vote unless somebody is contemplating changing their vote or there's something new at this point.
Yeah, let's get this out of the way.
I agree.
So do we have a motion? I think you made a motion
Yes.
to approve the resolution.
Approve the variance application with limitation that the variance is only for administrative offices for a home health care agency. And the question is open whether or not there would be a requirement that that be recorded. My recommendation is if the board were to grant the variance, that they make that a condition as well.
Okay, so there's the motion. May we have a second?
Second.
Thank you.
And Mr. Don,
Yes.
Mr. DeScala,
Yes.
Mr. Polipiano,
No.
Mr. Reeves,
No.
Mr. Semper,
Yes.
Mr. Shapiro,
Yes.
and Ms. Warren.
No.
Application's denied.
What's the final count?
4-3 again.
4-3 again.
Wonderful. There's not much more I can do, and unless they instruct me, I'm not going to go before the Superior Court in Newark. I don't know what else to do. I mean, I truly believe that the majority vote is in error. It's wrong. They're going to be an asset to that community.
Okay, Mr. Friedland, we voted. You were chair once. The vote has been taken, so we need to move on to the next case.
So we're done.
We're done. Thank you. Okay.
I'm not happy.
Mr. Chairman, I have copies of the comments to the resolution. Do you want me to distribute those, the ones that you and Mr.
Yes. Okay, so we're moving on to the approval of resolution for Seton Hall University, the parking deck. And this was an unusually long resolution. I think it was very well done, but in any resolution of this length, there'll be a few hiccups. And we've received the comments in here, and I agree with the suggestions. And in fact, I made a couple myself to clean up some of the language. Here's the one on item 7. Mr. Adler and I worked on, and I've worked on it again. Dennis Garabini was recalled and, responding to board questions, testified that students who cannot find parking park on local streets. I then added, Seton Hall administration has reports that exit interviews state that there is not enough parking on campus and that people are afraid to leave campus during midday, blah, blah, blah. That makes sense of that sentence.
Yeah, that's good.
And then there was another question about the date of the master plan from Seton Hall.
Mr. Chairman, I saw that remark. First of all, I saw all the comments. I thought they were all good ones and should be incorporated. With regard to the master plan date, Jetty, we checked on that. It's April 25th, correct? And that was in
This year?
13, yes.
Okay.
Any other comments?
I guess there's this other one on item 12. I think it's just a matter of cleaning up the wording. It says that the space between the wall and the boundary line is only 5 feet. I think it should say then 5 feet, but in some places as much as 20 feet. I guess I didn't hear that.
Okay, I see what you mean. That'd be the third sentence, the
Yes.
third line down in 12. But in some places, as much as.
Right.
Okay.
As much as.
The only other change I had, Mr. Chairman, was in paragraph 27, third line down. Illegal parking should actually be illegally parking.
Right.
And as I said, there were a number of other minor changes which you suggested.
Okay, so with these changes, do we have any comments?
I think I think it's a very good resolution that summed up a lot of testimony and a lot of information.
May we have a motion?
Move to approve this resolution with the changes that have been made to the text as we just reviewed.
We have a second?
My second.
Okay, Mr. Don,
Yes.
Mrs. DeScala,
Yes.
Mr. Polipiano,
Yes.
Mr. Reeves,
Yes.
Mr. Semper,
Yes.
Mr. Adler,
Yes.
Mr. Shapiro,
Abstain.
and Ms. Werner.
Yes.
I would only add that you need to put the vote on the last page. It's blank. Small detail.
Okay, so now we move on to the applications for completeness. We have 3 completeness applications tonight. We've had a full docket for, you're looking at me with a confused look. Ms.
Oh, Mr.
Warren.
Adler came back, so I
Oh.
guess I don't vote anymore, right?
Not tonight.
Okay.
So actually, if you don't mind, just a point of business, maybe out of order, but with regard to votes from not active board members, it seems like it might make sense to have those votes, especially in light of what happened that we had to go through tonight, to have those votes even though they may not be counted. So they'd be a placebo vote, but in the case where a board member after the fact has to recuse themselves, then you have that vote. That's just a suggestion, but one we might want to consider.
Makes a lot of sense, but MLUL says just the regular members are enough needed to make 7.
So we can't do the in abeyance vote?
Makes sense, but no.
Okay.
Makes too much sense.
So
Too much sense, right?
we'll have no more of that, Mr. DeScala. All right. The applications for completeness, we've been backed up for a number of months now, and the economy's getting better, and people are starting to come before us. We have a dentist waiting to see us for a couple of months. I'd really like to, at the very least, get through to be seeing Dr. Singla this evening. In order to get that far, we have to move quickly. These applications for completeness tonight are relatively small applications, and I'm not going, unless somebody else has objections, I'm going to move quickly through them. I'm not going to march down every item like I normally do on a big application. Okay, so the first one we're hearing for completeness tonight is case 1007, William and Janet Perlman, 267 Richmond Avenue. This is a C variance. They're seeking to build a one-story addition in the rear yard that encroaches upon the accessory structure separation from the principal structure. Do we have any representative from the Perlmans? Okay, none. All right, so we have Ms. Gruhl's review, and you can see there it's a relatively short review. Ms. Gruhl recommends that the application be deemed complete, given that it's a minor application and that sufficient information has been provided. The only question I had was this issue of item 15. They've not submitted a digital copy. Again, this is one of these items that we've never really thought about before. This is required, but our board has dealt with hard copies, but that a digital copy could be a condition of any approval. Okay, so we don't really need it for completeness then. Okay, correct?
Right at this point, Mr. Chairman, it is a checklist item technically. However, there may be a suggestion that that be stated as a matter for final or afterwards. It is helpful, but it would be at the end of the application.
Yeah, I would think that it's not particularly useful to have it, given the fact that it may change based on what happens during the application. It would be good to have a digital copy of the final approval.
Okay. All right, other than that, I didn't see anything that arched an eyebrow.
I only have one thing, Mr. Chairman. Item 44, the location and use of all structures within 200 feet. I'm not looking for 200 feet, but I think it would be useful for us to see the neighboring properties on both sides relative to the property line, because the drawings that they gave us sort of look at this property in isolation. And I think just a little bit of context might be helpful, because having driven by that property, the houses are pretty close together.
Would you require architectural renderings or photos like they've presented in their application?
Well,
The photos aren't adequate. I have the same
What I would suggest is that the drawing that they gave us, the proposed plot plan, be expanded and show us the houses on either side. I don't need to see floor plans of the houses, just the outline relative to the property lines.
Okay. All right, that's a good suggestion. So we can make that a condition of completion.
Right, I don't think we need it for completeness, but I'd like to have it before we hear the application.
Right.
So what you normally do as a board is if you, it's subject to receiving it 10 days prior to.
Correct.
The other thing that I would add, and this isn't, I don't know if it's required or not, but some kind of a correspondence from the fire department, because I think that this particular ordinance is related to, relates the proximity of the buildings to the outbuildings, so that the fire department can get their ladders up on the roof of the building or the outbuilding. And so I don't think that that's an issue in this particular location, and it'd be great to hear from, it would help the applicant if they had something from the fire department about it. So it's not a condition for completeness.
Can we
it's just
ask
a remark.
one of the firemen or the chief?
Yeah, we can forward the application to the fire chief and ask him to review it.
Okay, great.
Because we're actually getting a second completeness application this evening, that it's a similar issue of encroachment on that setback, as it were, from an accessory structure. And I've never, in all these years, heard a cogent reason other than it has to do with fire safety. But we've routinely violated it.
But when you think about it, it really makes no sense, considering that the side yard from the neighboring property is only 4 feet.
Okay. So Sal, could you forward this to the chief and see if we could get some sort of paragraph, if not actual testimony?
Yeah, we'll ask him to do a review.
Okay.
The application, make comments.
All right. And then, so this is conditionally complete, assuming that they will send us some basic rendering of the houses on either side of their house. And who is going to contact the applicant? Whose job is that?
I will, Mr. Chairman.
Mr. Dwyer, thank you. Okay. All right, with that being done, may we have a motion to deem this complete, conditionally complete?
So moved.
Second?
Okay, Mr. Dunn?
Yes.
Mr. Scala?
Yes.
Mr. Parlapiano?
Yes.
Mr. Reed?
Yes.
Mr. Semper?
Yes.
Mr. Aller?
Yes.
Mr. Shapiro?
Yes.
And Ms. Warren?
Okay, now we move on to case 1008, Ian Betts, 72 3rd Street. This is a D variance seeking to permit a 5th unit within the existing 3rd floor space. Again, this is a completeness hearing. Ms. Birkenwald, how are you doing?
I represent the applicant, Ian Betts. Since getting the memorandum, we've supplied digital copies, the property owner's list, and my client is looking for the deed and... Pull the mic down, please. Oh, I'm sorry. Since getting the memorandum, we've supplied the property owner's list, the taxes paid. My client is searching for the deed, but we are not making any change of land. There's an existing lot, it's almost 18,000 square feet. It's triple the size of what's required for a two-family house. There's existing bedroom space on the 3rd floor, and there's one staircase, so that
Okay,
there really isn't
Ms. Birkenwald,
privacy.
this is only for completeness.
Right.
Do you telling us stuff that we don't need to hear tonight?
I think I'm addressing just some of the, maybe I was talking too much, but we're not proposing a single change to the exterior of the building. It would just basically be changing a bedroom into a kitchen and making the 3rd floor bedrooms into a separate unit. So the exterior of the building will not be changed.
Thank you. Okay, in looking at this, I've checked off that you have sent today item number 4, tax collector certification, and the certified list of property owners. So that came today, thank you. There was a question of the applicant should clarify whether or not any lands will be transferred.
No lands will be
so
transferred. The
then-
lot is an existing extraordinarily large lot.
And then I will move forward in taking Mr. Don's cue.
Excuse me, President. I just have a question. Do we have to be concerned with non-conforming use if it's a multi-family in a two-family zone?
First of all, you need to speak into the mic. The question is, do we need to be concerned about multifamily use in a non-conforming use in this zone? Well, I think what you may be getting to and what was hinted at in the application is it may not be for completeness, but for the purposes of this board, you'll need to show whatever kind of legal history you have about how this got to be a 4-unit building. Because you're probably aware of this. This comes up in these old places about, was it, pre-existing non-conforming, or was it always non-conforming?
The building is about 100 years old, and the 4 units predate zoning in this.
And so bring any kind of legal confirmation of
Yeah,
that.
there was once, about 20 years ago, and I got a copy of the resolution. Perhaps you'd want, I'll get it copied before the hearing, that acknowledged that this is a legal, non-conforming 4-family.
'Cause that can be
Somebody applied to make it into, I think it was 18 or 20 units.
Okay, so whatever you have, because that can be a sticking point sometimes.
Thank you. I will certainly supply you with the documentation.
Is that answering your question?
Yes, President.
Okay.
Thank you.
Now, along what Mr. Don said in the previous completeness application, do we have the structures on either side?
Yeah, they show, and in this case, since there's really no proposed change to the outside, I have less of an issue with this than I did on the last one. So I think that the site plan that we have and the drawings that we've been given are sufficient for us to talk about what we're looking at on this property, because it's really an interior issue, an interior and a bulk issue.
Okay. Anybody have any other concerns? Ms. Gruhl?
As much as we note that they did provide the structure location, it would also be helpful, and even if it's in testimony, identify the uses of those structures surrounding. And that's in our memo.
Okay, did you get that, Ms. Birkenwald?
Yes.
Okay.
Yes, we will come, I had planned to come with a planner and perhaps just an architect, because since we proposed no site changes and we did supply a site plan, I didn't really think I needed to have a surveyor testify, but if the board thinks they might have some questions, I could certainly arrange to have a surveyor here. I didn't really think it would be necessary. But if the board...
I don't think the issue is one of a survey and its use.
I think that your planner can adequately address in the testimony as to at least that issue of the uses, because that would be part of the normal testimony that that person would provide anyway. So from our perspective, it wouldn't require a surveyor.
Thank you. And of course, if questions do arise, which I really don't expect, we could always come the next time, but I didn't think I needed to drag this out. It's not that complicated.
Do we have any other comments on this completeness application? Okay, may we have a motion?
I'll move that we deem the application complete.
Second.
Subject to the conditions in the memo.
I second that.
Okay, Mr. Don,
Yes.
Mrs. Scala,
Yes.
Mr. Polipiano,
Yes.
Mr. Reeves,
Yes.
Mr. Semper, Mr. Aller,
Yes.
and Mrs. Shapiro.
Yes.
Thank you very much.
Thank you. So we move on now to the third completeness hearing, case 1009, Ellen Butler Bicales, block 2101, lot 18, 275 Richmond Avenue, C variance. This applicant is seeking a variance to build a deck over the footprint of an existing patio, and again, it encroaches upon the accessory structure garage. Do we have any representative? Come on up, please. Hi, can you state your name, please?
Yeah, I'm Ellen Butler, Bicales.
Did you have anything you wanted to start out saying? You're the homeowner.
I'm the homeowner, yeah, and I took notes of what you were looking for from the Perlman's application.
Okay.
So I assume it's the same questions. I guess the question I have is about the, do you also want to see the houses on either side for mine?
Do we want to see the houses on either side? We usually do.
Yes.
Okay. And would it be helpful for me to coordinate with them to get the fire department to come out and just take a look at what the issues are and have that report come through us?
We can forward the application to the fire department and ask the chief
You'll do
to
that,
comment on
okay.
it.
Okay, when
So
he
you can
comments,
discuss it.
will he write something, or does he have to show up?
Typically, it would just give us
Typically, it would just be
report.
a memo.
Yeah, that would be fine. I don't
Regarding the
think we need it.
application and any concerns that he may have.
It's kind of a generic consideration.
Right.
Okay.
So, I
That would
mean,
be
if there are
great. So we're-
concerns, then we
we're
either
gonna
address
try to
them.
do that.
You can ask the chief to come, if, after you get the memo, if there are things, questions, you can ask him to attend if he's available.
Okay. All right, so we'll get, that will be a conditionally complete pending the structures on either side of the applicant's property. I didn't see anything else in here that I questioned. Does anybody else have anything? No. May we have a motion?
I move that we deem this application complete with the provision that the neighboring structures be provided on the drawings that they'll be presenting at the public hearing.
And I'll second.
Okay, Mr. Don,
Yes.
Mrs. Scala,
Yes.
Mr. Polipiano,
Yes.
Mr. Reeves,
Yes.
Mr. Semper,
Yes.
Mr. Aller,
Yes.
and Mrs. Shapiro.
Yes.
Thank you. Okay, so now we move on to the full applications. I should note that Fairview, which would have been first on the docket at 7 Fairview, has been carried to the November 7th meeting. So they will be first on the docket on November 7th. So again, it behooves us to move expeditiously. Next is Seton Hall University, 519 South Orange Avenue. Applicants requesting a use variance in the alternative to the appeal of the zoning officer's decision.
Good evening, Mr. Chairman, members of the board. Kevin Coakley on behalf of Seton Hall. This was carried from September 3rd. As you indicated, it's sort of a bifurcated application. There's the appeal, and then there's in the alternative, there's the use variance. The zoning officer, I think acting conservatively, denied the zoning certificate. This property is in the RA 60 zone. It had been the subject of numerous variances over the years, including a variance that allowed the entire structure to be used for professional office use. There had also been variances for childcare. At the end of its life, before Seton Hall bought it earlier this year, there was a medical office on the first floor, and there was some sort of dispatch service on the second floor. The third floor was vacant. Basically, a use variance runs with the land, and there's a case called Stop and Shop, which is the the keystone of when a use variance is substantially similar so as to be carried forward and given effect in a subsequent application. Stop and Shop involved a department store variance, and the court said that in that case, allowing the use of the same property for a supermarket was within the ambit of the variance given for the department store. And, maybe when I sum up, I'll read a passage or two from that case, not to waste your time right now, but that's essentially the argument. And in this case, I think it's very apropos given two factors. Number one, parking is the same for a professional office use as a general office use. And number two, the definition in the zoning ordinance of professional office building conflates the two types of office uses. A professional office building is defined as a building designed to contain one or more rooms or suites of rooms in which professional or business offices are contained. So at least within that provision of the statute, a professional office use is deemed comparable to a general office use. And so while and I think it's pretty common for zoning officers to take a conservative view, I think if you consider the factors here that these types of uses are really substantially similar, they would meet the test of Stop and Shop. And so the simple course would be to grant the appeal. In the alternative, Seton Hall seeks a use variance to use the property for its office uses. And the plan is to have people who would be in the financial and public relations fields of university employees using the building. So I think you'll hear, as you hear the testimony, we hope you'll agree that there is proof presented on each of the theories of the variance, which I'll get to in a minute. But you'll hear Mr. Signorello from the university who will testify about the use and various factors, including the parking and matters such as that. Ms. Betsy Dolan will give testimony regarding traffic and parking. And Mr. Steck is here. Peter Steck will give testimony with respect to the variance and the appeal on the issues of planning. I think the various theories on the use variance are several, but it certainly is particularly well suited for office use. It's inherently beneficial as given its relationship with the university. And I think there's also, given the fact that this building was being emptied out by the tenants at the time, there's probably a hardship case to be made here. But certainly the cases concerning the particularly well suited for office use and inherently beneficial, I think are strong proofs with respect to this variance. So with that said, I'd like to call Mr. Signorello.
We should first decide upon whether we accept the zoning officer's argument that turning down this proposal that professional office and general office are different. And I had a question on that. In the process of that, do we vote on it? Is this consensus? Do we make a motion just like we do on everything?
Sure, there's an application for an appeal from that decision, so it deserves a vote.
I think the most expeditious way might be to hear all the evidence and then vote sequentially.
I guess it's their call, right? That's what they want to do. But I mean,
because if the board were inclined to,
if we're inclined to say yes, you can go home.
Right.
We're glad to say yes. We'll gladly go home.
If we're inclined to say no, do they get another crack at it?
They do. They have an application for a use variance.
Can we?
Well, right, but they don't open up the reinterpretation though if we vote them down.
The appeal would be denied, but the application for use variance
Right.
would be open.
Okay.
It might make sense. I don't know if the order again is right, but to hear from our zoning enforcement officer before we hear from the applicant, just to see what the rationale was.
Yeah, let's hear from Mr. Rinda.
The applicant applied for a use permit to turn the current facility, which is offices, professional offices on the first floor with a daycare, which was approved prior upstairs. They submitted the resolutions of approvals for prior variances. As you go through the resolutions, it talks about different pieces to the building. I have the resolutions here that were with the application, but I think I may be missing one. How many?
We have 4, our earliest is 1982.
The earliest one, okay, from 82. It's not specifically clear. I mean, the later application regarding the child care facility, is definitely clear. But the approvals were for professional offices, and by definition, professional offices are permitted in residential zones as conditional uses. If you don't meet the conditional use, you can go to the board for a variance for that conditional use, in which time the boards typically apply certain restrictions, conditions on that variance. A general office would not be considered a professional office or a conditional use in this zone. The university is proposing offices for staff, and it's debatable whether or not they're professional offices, but our typical definition of professional offices in the ordinance are attorneys, accountants, architects, licensed professionals by the state. And that's the way we've been enforcing the ordinance since I've been the zoning official. That's why I was inclined to deny the application as presented for the use permit. So in addition, even though the change in use most likely will not affect the parking, there is that consideration as well, because they did get the variance for the daycare, which is a slightly different type of property, but it would be less circulation. But again, the board may want to consider the parking as well in hearing the application. I don't know that it's necessarily a major issue, but that's something else that I think the board has to consider as well, in that type of a change in use.
So we've got 4 resolutions here. The most recent one is from, 94. That was the one where the ground floor is professional office and the upper 2 floors were daycare.
Right.
So that's
and
the one
there's also
that's
conditions placed on that, on the number of professionals.
Okay, so that's the one that's current.
That's the most recent.
Right,
yeah.
and then there's one before that that's from 87, which permitting the entire 3 floors of the subject premises to be occupied and used by no more than 3 separate professional uses as that term is defined in the zoning ordinance. So 3 doctors.
3 doctors, right.
Okay. But, so how does that work if there's, so the one from 94 supersedes the one from 87? The one from 87 is no longer, like...
Again, it's not clear. In 94, if that was the intent, the resolution, I think, should have, basically, represented that. Assuming the applicant would agree, okay, we're giving up this use, but put that in that resolution so it's clear that this one supersedes this one. I don't know, and that's a legal question for council, if the one for the 3 professionals is still in effect. I assume it is. But again, what they're proposing are general offices,
right,
not for 3 doctors or 3 professionals and their staff. They're looking at putting in, general offices. And it's, again, and then that's an application I think the board needs to consider so they have a handle on, okay, well, how many office spaces are you looking at? How much area are we talking about? Are you going to have 8, 10, 15, 20 people working in this space?
But the thing is that the application from 87 that dealt with 3 separate professional uses didn't speak at all to how many people worked in each of those offices.
No, it didn't.
Right. So the issue of, not that it's not an important issue, but the issue of how many people, it's not like we have something to compare it to,
No, and that's why you want to look at it now.
And-
What's being
and
proposed,
your-
so
Your interpretation that this, as general offices, is not a permitted conditional use in this zone?
or it's not a permitted use or a permitted
Or-
conditional use.
Okay, got it. So if it was determined to be professional offices, it would be a conditional use, and then we would sort of look at this differently.
Yes.
Okay.
That might be heard on just the discussion. I think a use variance runs with the land, and unless it specifically is superseded by a subsequent use variance, it continues to run with the land. So I think that the variance allowing the entire building to be used for professional office space is still applicable. We're really not arguing here that this financial PR use is a professional use under the definition of professional use in your ordinance. So that's not the argument. The argument is that's not the law. The law is that the use needs to be substantially similar. And, you know, in a rare case, the New Jersey Supreme Court has really laid it out for us pretty well. It says, this is in the Stop and Shop case, a 2000 decision. The lesson is that in granting use variances, boards of adjustment must anticipate that users in the same use category as the applicant, but with different merchandising characteristics, may someday occupy the property and claim the benefit of the prior variance. The question is not whether the successor use is essentially duplicative of the use for which the variance was granted, but rather whether, considering all relevant factors, the successor use is sufficiently similar to the variant use to afford it the benefit of the variance. We reject as too restrictive our colleague's standard requiring the successor or use to be duplicative of the variant use. And it goes on to that effect. But so, you know, in our view, it's a substantially similar use, same parking characteristics. It's also mentioned in the ordinance in the definition of professional office building. And so, you know, we think there's grounds why the appeal should be granted.
That argument, by the way, is why I'm concerned always about granting these sorts of use variances, particularly in residential ones. And that's kind of a generic comment for the board's consideration. Let me ask it this way. Does the board want the applicant to go through all the testimony and bring all the people up here before we vote on the interpretation of the zoning officer, or are we ready to vote now?
I'm ready to vote now, but that's just me.
Yeah, I'm ready to vote now also.
You know, the only, I guess, having said I'm ready to vote now, can I ask one question, which is I'd love to hear from our attorney about the statements from our esteemed engineer, just that, you know, there's a question here about the definition of a word and whether our ordinance or the case that's being cited rules and, you know, a couple of things like that. I appreciate your guidance on those.
My understanding of Stop and Shop case was that the court was very, very narrowly stating, Supreme Court of New Jersey was stating that if the two uses were within the same use category under the ordinance, that they would both be available, subsequent users in the same use category. And it so happened under the Milburn or Springfield ordinance that the supermarket use and the retail shopping center, retail Saks Fifth Avenue use were in the same use category under the ordinance. And that's what the Supreme Court hung their hat on. I think the zoning officer in this case, as you said, took a conservative approach that there is a difference between professional and general office use, and I think there's a certain logic to that.
And is it just I apologize, but just, so it is the case that under our ordinances, we make a distinction between professional offices defined as licensed by, you know, professionally licensed workers and general office. We make that distinction in our ordinances.
Yes.
Yes, we do.
It's in the
Definitions.
It's in the definition. It's in the definitions, and we have it in our application materials of the definition of a general office versus a professional office and its associated professional person.
And section 214 also talks about professional offices.
I think if this,
So there is a distinction there are more than one distinction in the ordinance, and I think that's probably the basis for Sal's decision.
I agree that there is that distinction, but I think that the heart of the Stop and Shop case is, you know, if you could compare a department store with a supermarket, which are very different uses, but yet the court felt that they were similar enough that the department store variance carried forward to allow the supermarket use. I think, you know, and as we're comparing here professional offices versus general offices, I mean, it's hard to walk too far away from that Stop and Shop case and come to the same answer.
But I think the Stop and Shop case is just ripe for reversal on that issue. And it's continuing to be litigated to this day, and eventually I think the court will come to its senses and say there's a huge difference between a retail store and a supermarket and the impact on the neighborhood.
Yeah, but there's a probability that we're going to listen to the matter carefully and probably agree that that we ought to grant the variance.
Let me just, let's just, again, before testimony, but really what we're discussing here is the reason for this distinction, and I think I think the question would be, are we opening up by granting general office use variance, are we opening up to a much wider range of uses that might in fact have very different site impact in terms of parking or load on the site? You know, that's the question in front of us, right, is that, and I think
you're right, and I think the even more dangerous approach would be if this board would take the opposite view that Sal took and say that, as far as we're concerned, professional office use and general office use are the same.
Well, then suddenly, right, that's right. All right.
And that's my concern too. Intuitively, experientially, as well as just the plain letter of the ordinance makes a distinction between general office and professional office. Could any particular use of a general office be similar to a professional office?
Yes.
Of course it could.
Right.
But general office seems much broader.
Right.
You know, and I could even imagine, though, some professional offices could be pretty intensive use, though, and some general offices need not be. But the fact is I'm giving away the way I'm going to vote. I'm sorry. Is there's differences.
But the interesting thing is when you get, you know, our ordinance is always good for a review. But when you review the parking schedule, it doesn't even address general offices. It says business, professional, and executive offices. So it throws a whole different set of categories in there. So it doesn't even technically address general offices in the parking requirements.
Well, I think we've been using general offices and business offices interchangeably.
I'm not saying that your interpretation is wrong. I'm just saying that our ordinance is not consistent.
So again, unless we have more questions on this, do we want to proceed with more testimony before we vote on the interpretation? Or do we want to vote on the interpretation?
Let's proceed with the matter because I think that we got to put time into this and then time into that. Let's just put time into hearing the matter.
Testimony will not be additional, let's put it that way.
Let's just.
You'll hear the same testimony either way.
I'm sorry.
I don't see why we don't take a vote on the interpretation. It'll take 5 minutes, and then if we vote it down, we go to the application.
That's what I would prefer to do, but we would need a motion and a second.
Okay, then I'll make a motion. I make a motion that we, what's the correct word? We overrule the appeal of the zoning officer's decision. And we allow them to occupy the building for general office use.
Okay, so that's, be clear on that motion. Your motion is to overrule the zoning officers.
Correct.
Okay, do we have a second?
Second.
It's an odd way of stating it.
Yes, and And so just to be clear, for us simple minds down here, a no vote means we are voting to
Keep,
Uphold.
To
uphold.
To support,
correct,
the zoning,
to
right.
buttress.
right.
Okay, so we have a
And
second.
a yes, a vote yes?
A yes would be to,
Overturn.
yes, overturn.
And would that mean that we don't hear the matter anymore?
Correct.
That's correct. Okay.
Okay, Mr. Don,
Yes.
Mrs. DeScala,
No.
Mr. Polipiano,
No.
Mr. Reeves,
No.
Mr. Semper,
Yes?
Mr. Aller,
No, I'm voting to agree with the engineer.
and Mr. Shapiro.
Yes.
Okay, so it's 4-3.
Bring on the testimony.
No, so we bring on the testimony.
Okay. All right, Mr. Signorella? Yes, ma'am.
I'm sorry, Mr. Signorella. Go ahead.
Do you swear or affirm the testimony you give here this evening is the whole truth?
Yes, I do.
Please state your name and address for the record.
John Signorello, 400 South Orange Avenue, South Orange, New Jersey.
Mr. Signorella, you employed by Seton Hall University?
Yes, I am.
And what is your job?
Yeah, excuse me, we're getting the high sign here a lot. You really need to talk into the microphone. Do we only have one microphone?
Second one.
Does that cord reach up, that you could just bring the,
It doesn't look like it's long enough.
You want to stand down there, Dan?
That's going to look really awkward, talking to your expert, talking from the mosh pit down there.
The mosh pit.
There you go.
all right. Good thing we brought Mr. Garabini.
We need a gaffer.
He's the best boy. He's the
Garbini did summer stock at one time.
How's that? How's that?
Is that working for you all back there? Okay, great, thank you. Okay, go ahead.
All right, what is your job at Seton Hall?
I'm the Associate Vice President for Facilities and Operations.
All right, and as part of your job duties, were you involved in the acquisition of the property at 519 South Orange Avenue?
Yes, it was.
All right, when did you first visit the property for the purpose of looking to acquire it?
I believe it was late in 2012.
All right, and what was the condition of the property at that time?
The condition of the property, the third floor was unoccupied at the time. The second floor had a partial occupancy of like a dispatch center for trucks that support laboratory operations. And the first floor was a physician's office.
All right. And did Seton Hall investigate the neighborhood of the property?
Yes.
And what types of uses surround the property?
As you go down South Orange Avenue from 519, there's a number of other office uses along South Orange Avenue.
All right. And did Seton Hall ultimately acquire the property?
Yes, we did.
And when approximately was that?
That was at the beginning of 2013.
All right. And since the acquisition, have you examined the property in terms of its interior space?
Yes, we have.
All right. And what is the net interior space in the property?
It's 4,927 square feet.
All right. And how did you reach that determination?
We've had an architect come in and do existing floor plans of each of the four levels, including the basement.
All right. And
Could you tell us what that includes?
That includes the net usable space on levels 1, 2, and 3.
So nothing on the lower level where the garage, doesn't include the garages and the
No,
basement?
that would not really be usable space for office use.
And did you consider the amount of parking that would be necessary for that net amount of space?
Yes, we did.
And how many spaces are that?
We're providing 23 spaces on the property.
All right, and is that at one space per 300 square feet net?
Yes, it is.
All right, so you don't need a parking variance?
No, we do not.
All right. So is there a loading dock needed?
Not as part of the operation, no.
Okay. Are there garages as part of the structure?
Yes, there are 5 garages.
All right, and where are they located?
They're located under the building.
All right, towards the rear?
Yes, they face the rear of the property.
And what is your plan for those parking spaces?
They would be used for storage and access into the basement.
Okay. Do you anticipate any physical changes to the property in terms of landscaping or lighting or matters of that sort?
The most we would do is general landscaping, some aesthetic upgrades to the exterior, such as paint, that type of thing, but no physical changes to the exterior.
All right, would you anticipate significant visitors coming to the property?
Not for this office.
All right, and what would be the type of initial use of the property by the university?
Again, as you had stated, we're going to be looking to use the property to have offices for public relations and finance type folks.
Okay. Would students be typical visitors?
No.
Now, is the proximity of the location to the general university campus, is that significant?
Yes, it is.
All right, and just why is that?
Just because there will be interactions between the people in this building and possibly people on the main campus as well as other university buildings in South Orange.
Okay, and is there any physical change contemplated in the structure itself, at height or width or anything like that?
No, there's no physical changes proposed.
All right, and
Yes.
Thank you.
You have to stand up taller now.
Do you anticipate any deliveries by truck or anything like that?
Typically, deliveries all come into the central mailroom on campus, and our internal mail van will make mail deliveries and packages.
So it would be light delivery by van, is that
Yes, by van.
correct? I don't think I have any further questions, Mr. Signorelli.
The 5 garage spaces are not included in the 23 parking spaces, correct?
That's correct.
Is that because they're not going to be used for parking, they'll be used for storage or something like that, or?
They'll probably be used for storage.
Probably or would be.
Would be.
I don't know if Mr. Signorella could answer this question or not. Maybe this is for the attorneys and our zoning officer to consider, is that this is going to be used right now for general offices, in this case, financial offices. Are classrooms considered offices? I wouldn't think they would be, but, given that it's an educational institution.
The classrooms would not be considered offices, but the prior variances that were granted allowed for a daycare, so the board may want to consider whether that would be a similar education use. I'm just
Daycare
throwing
for
that
your
out
college
there.
students?
Well, but
Would that be an abandoned
you again, that's something that the resolution should be neat and clean, and and with the applicant's agreement, make sure that there isn't going to be any conflicting uses that have been
The
approved.
variance application is for office use, not classroom use.
And you consider that a difference, classroom use versus general office use?
Yeah, we're not applying to use it for a classroom use.
Mr. Dwyer, do you think those two are sufficiently different, that general offices, we don't have to worry about classroom use?
I think, yes, I agree with Sal, and I would also state that if the board were inclined to grant it, that the application is stipulated he's not seeking that type of variance.
Okay.
Because I thought the testimony was for PR and marketing.
PR and finance, yes.
Financing, okay.
Do you have other questions?
I do, Rusty.
Yeah, Mr. Adler.
The office uses you said were on the block. Are those the office uses that you're talking about general or are they professional offices? Let's say on either, well, we know that the one to the east is general offices, is that correct?
The building to the one side is our building,
Right.
where we do have some offices, yes.
And is that fully occupied?
Yes, it is.
Okay, and to the west, what's the building there?
I know there are some professional offices. I can't testify that as you go down the block that they're all professional offices.
Do you know any that's general offices?
I don't know exactly.
And you said the architect figured the square feet. Do you have the plans where he figured that, or letters?
We do have floor plans that document that, yes.
Okay, and that's in your package?
I don't believe, yes, they are.
Okay. You said you don't envision significant visitors. What's significant?
In terms of, it's not an operation where you have people visiting all the time. It's not to say somebody might not come there and visit the office, but it's not a high turnover.
What would you consider a high turnover? How many per hour, how many per day?
I don't have that number.
Okay. That's it. That's all I have.
Mr. Parlapiano.
Can we just go through the other properties around? I just want to go a little, just, the other properties that Seton Hall owns in that area. 602, Lot 27, on the other side of Terrell. That's, what's that used for?
There is, on the corner of Terrell and Center Street is our health services building.
Right. And is that general office use?
That's our student health services.
And then on the other side of Terrell, the corner lot, number 15 is?
That would be our 525 South Orange Avenue.
Right.
That's primarily used by admissions people. Admissions, student admissions.
And the next one down Terrell, lot 14, is residence, is that right?
That's student apartments.
Right, student apartments.
University apartments.
And then further down Terrell, lot 11.
I believe that's across the street, 395 Terrell.
You know, does somebody know if that's 395?
The lot 11 is 376 Terrell.
I'm sorry?
Lot 11, if you were talking about lot 11 on Terrell, that address number is 376.
Okay, so 376?
I'm not familiar with that address being owned by the university.
90411, let me just check, make sure. No, I didn't. It's listed as a Seton Hall building on here, right? So block 904.
376 Terrell is William and Donna May Roth Owens.
I'm sorry?
376, lot 11 is not owned by Seton Hall. I think that's a house.
The only other property that Seton Hall owns on Terrell is the one directly behind our health services building, which is across the street from the student apartments. That's 395 Terrell, and that's a vacant building.
Wait, I thought 395 was the health services building.
No, 395 is the vacant building behind the health services building.
I see, so lot 26 is the health services?
I don't have the lot map. Yes, it is.
So, I'm sorry. So, let's just go through this again. So, on Terrell, 395 Terrell.
Yes.
which I thought you had, by block and lot, I thought you said health services, that's vacant.
No, the health services building is at the corner of Terrell and Center Street. Lot 20, thank you, Mike. Lot 26 is our health services building. Lot 27 is the vacant building, 395 Terrell.
Right,
Lot 14 is the student apartments.
right,
Lot 15 is 525 South Orange Avenue,
yep,
which I said is primarily
admissions,
admissions people.
right,
And the parking lot, Lot 16 is just a parking lot. And Lot
Okay.
17 is the application we have before you.
right. And lot 11,
Lot
so
11.
90411 down Terrell?
Lot 11 is not owned by the university. Lot 11 and 12 are not, and 13 are not owned by the university.
Okay, on the, if you look at the legend on here, if you flip over to the legend, just flip the side, 90411 is listed as Seton Hall University.
Excuse me, can I ask you? 90,
So block 904, lot 11
Yes.
is listed as Seton Hall.
not on my drawing. It's William and Donna May Rolfe Owens. Lot 11?
Am I reading things
When you're
wrong?
looking on the actual architectural plans, it does say Seton Hall University.
Yeah,
Number 11, Seton
but
Hall.
maybe it's obviously, I guess it's wrong.
Yeah, I'm
Then-
not
then
not
it
sure
says
which,
it's-
I'm looking at the cover sheet for Seton Hall University variance plan.
Yeah. So 376 Terrell is not Seton Hall.
It's,
That's
are you looking
correct.
at the old plans or the more recent one?
Yeah, on the, we need to make sure we're looking at the drawings that are revised 8/14/13.
They're stamped August 22nd.
We have two sets of drawings. One of them is in the revision box, lower right-hand corner. All three drawings are revised 8/14/13, and it should be stamped 8/22/13. There's a second set of drawings that are earlier, which has that property owner's list incorrect.
Okay, so I'm just looking at older.
On 904, on the correct drawings, lot 904, block 904, lot 11 is correctly identified. Right. Well, it's consistent with the property owner's list that was attached to the application, so.
All right, we cleared that up. We have
Oh, yeah,
other
cleared
questions. Mr. Parlapiano.
No, I have to think now.
We have other questions from the members of the board.
Rusty, I have one more, can I?
Mr. Adler?
Thank you. Mr.
the
Sigarelli?
story does tell me that we did incorrectly put the list on the first set of plans, so.
Thanks, I'm not crazy.
So you said that the building on the corner of Terrell and Center is your health services building, but what goes on there?
That's where we have a medical staff for student health. So if a student is ill, they would go over there and seek medical attention.
Infirmary or clinic, something like
Yes.
that?
Yes.
Okay.
So it looks like on the amended plans, on the property owner's list, that has lot 27 being owned by Seton Hall.
Yeah, that's what he said.
That's block 602, lot 27.
Right.
And that's the main campus, 400 South Orange Avenue, which is across South Orange Avenue.
No.
60227
It's
is owned by Seton Hall.
395 Terrell.
And you said it was vacant.
It's the vacant building, 395 Terrell, right?
Yeah, it's this one, it's just
So they own
vacant.
the vacant building?
Yes.
I see, okay.
That would be this one.
It's vacant.
Yes.
Okay.
Do you have other questions, Mr. Adler?
Nope. Thank you.
Any other questions? None? Okay, thank you.
Thank you.
I got one. Yeah, give that one to Nicole. That's hers. All right, I'd like to call Ms. Dolan for some brief testimony on traffic and parking.
Please raise your right hand. Do you swear or affirm the testimony you give here this evening is the whole truth?
Yes,
Hang
I
on.
do.
I'm sorry, Mr. Don pointed out something I forgot. We should have asked if is there anybody in the
All right.
public that wanted to question Mr. Signorella? No? Okay. Sorry.
Good point.
Go ahead.
Do you swear or affirm the testimony you give here this evening is the whole truth?
Yes, I do.
Please state your name and address for the record.
Elizabeth Dolan, Dolan.
All right, Ms. Dolan, what is your profession?
I'm a licensed professional engineer registered in New Jersey, New York, Pennsylvania, and Delaware, and I specialize in the area of traffic and transportation engineering.
All right, and have you been approved as a traffic engineering expert by this board previously?
Yes, I have.
I'd like to offer her as an expert in that field.
Do we have any questions? Okay, the board recognizes you as an expert.
All right. Did you look into the question of the likely traffic impacts as to the use by Seton Hall as proposed versus the prior permitted use under the variances?
Yes, I did. Using data published by the Institute of Transportation Engineers, the office use proposed by Seton Hall would generate approximately 82 trips over the course of a typical weekday, workday, compared with the prior resolution that was discussed earlier this evening with a combination of office and daycare, and that would generate over 150 trips, excuse me, over the course of a typical weekday or workday, and that higher trip generation, of course, is due to the pickup drop-off activity, primarily with inbound and outbound movements, both at the start and end of the day, whereas under the proposal by Seton Hall, the staff will come in the morning, leave in the afternoon with modest trips throughout the course of the day.
All right, and based on the testimony of Mr. Signorello as to the net square feet of space in the building, what would be the amount of parking required under the South Orange ordinance?
17 parking spaces.
And what is the ratio of that?
It's one space for every 300 square feet of net office area.
All right, and are there more spaces available than 17?
Yes, there will be 23 striped parking stalls. Those will be surface stalls, not garage spaces, and one will be for handicap motorists.
All right, I have no other questions.
So the 23 includes the one handicap?
That is correct.
Mr. Don?
Question for you on, and this deals with the trip generation manual for the ITE. Does it differentiate in that manual between general office and professional office?
It does, it differentiates between general office and medical office.
Okay.
But that there's no professional office category.
So would the trip generation for general office be less than that of a medical office?
Yes, it would be, because again, you have, with the medical office, I believe that total was in excess of 200 trips per day for medical office, because you've got the patients coming and going throughout the course of the day. So in that regard, professional, as it relates to a doctor, would have a higher generation.
And that really, it only differentiates medical office. It would not differentiate a lawyer's office
That is correct. In the ITE categories, the attorney or accountant would be included in the general office. It is specifically medical/dental that is differentiated in the ITE manual.
Thank you.
You're welcome.
Is the number of trips is related to the square footage of the building being used for offices?
Yes.
And so if it doesn't account for whether you make those offices smaller and have many people or luxurious like my office and fewer people?
That's correct. It's taken based
average.
on averages of various studies
And what's
conducted.
and for that, what is the, with that, what's that average, for an office, and how does that relate to the way this building is proposed to be divided?
Well, on a peak hour basis, for example, the trip generation would be 12. So if you're looking at, we've got 23 spaces and we've talked about an occupancy of somewhere in the range of 25 employees, that would suggest that about half of the employees arrive or depart in 1 hour, which makes sense because not everybody's on the same schedule. Some will arrive earlier, some will arrive later, and the same thing with departures in the afternoon.
I'm sorry, so that means that the 82 trips is based on based on 24 offices being in the building?
It's based on a ratio. I used actually the gross building area, about 7,400 square feet.
Right.
And the weekday ratio is just over 11 trips for every 1,000 square feet. So if you multiply the 11 times 7.4, it comes out to 82 trips for a typical weekday. And for medical office, it's much higher. Instead of 11 trips per 1,000 square feet, it's 36.13. So that gets you to 268 for a medical office.
So, I'll try one more time. So I guess what I'm asking is, did you think about the proposal of how many people to put in this space versus an average?
Only in the context of some of the project team discussions. I think the number 25 was talked about, and I think that makes sense with the 12 peak hour trips, with about half coming or going in 1 hour.
Okay, thank you.
You're welcome.
Okay, I have a question, just so I can understand your table here. Table 1 on the first page, you have 12 trips in the morning, 12 in the evening, that's 24. How do you get to 82 over the course of a weekday? Maybe, obviously, I'm interpreting it incorrectly.
Well, these are the two busiest hours of the day. And as we said, if we had somewhere in the neighborhood of 25 employees, we would have those people coming in, or most of them coming in. Some of them might not show up at any one day. Someone might be sick. But so the morning, the busiest 1 hour, we would have 12. But we might have 8 or so in the hour before and 3 or 4 in the hour after. And then there's FedEx and mail and people maybe going to lunch.
It's peak hour.
Yep, these are, table 1 is the busiest 2 hours of the day.
Okay. We have other questions? Mr. Adler?
Ms. Dolan, you said this is based on 7,400 gross square feet.
Yes.
Would it be, are there charts for net square feet, usable, net usable?
No, for the ITE calculations, we use the gross building area, the gross floor area.
Is that, why is that? Does that make sense?
Why is that?
Yeah.
That's the way the numbers have been calculated and presented.
Are there any manuals or methods of doing this that use net usable square feet?
I have seen some ordinances like yours that talk about net usable. I have been involved in applications where, for example, a large office building with atriums and those types of things, where we've looked at what is the habitable space, if you will, as opposed to some of those larger areas that aren't actually housing employees. But for the trip generation and ITE purposes, they've calculated the rates on that basis.
But are there other manuals other than ITE that use net usable?
Not that I'm familiar with.
Well, so I guess this is really for Mr. Coakley. Could you point me to where the calculation by the architect is to get the net usable?
It's in the application package, and I can't, but I will before we finish.
Okay.
Okay.
That's all I have for us.
Ms. Gruhl?
Yes, I just have a real quick question that I just want clarification from you. It's in our memo. In your professional opinion, is the location of the handicap space acceptable from a circulation perspective, and where handicap spaces have to be located?
I can only answer that from the perspective of knowing where it's located and on the driveway. Its accessibility for a driver, I would say, is fine, but I can't speak to the architectural and the door access.
Right. I was just meaning in terms of the accessibility of cars, the circulation pattern, and how that handicap space is related to that, as well as...
There's certainly the maneuvering area to get into it. I know that it happens to be the location of the existing handicap striped space on the site, but I haven't evaluated it any further than that.
Okay, but from your perspective, it's acceptable in terms of where it's located?
You can certainly get into and out of it. There's maneuvering room, and there's circulation around the building with other hatched areas for extra maneuvering, so certainly someone's not going to back out of the driveway from that spot. I think they would pull back, excuse me, and then circulate through the back parking lot and then exit driving forward out onto South Orange Avenue.
Thank you.
You're welcome.
Other questions? Okay, thank you.
You're welcome.
Questions from members of the public? Okay.
Please raise your right hand. Do you swear or affirm the testimony that you will give here this evening is the whole truth?
Yes.
Please state your name and address for the record.
Peter G. Steck, S-T-E-C-K, 80 Maplewood Avenue, Maplewood, New Jersey.
Mr. Steck, what's your profession?
I'm a licensed planner in New Jersey.
Have you testified before numerous boards and been qualified?
I think he's hearing you.
I'm sorry. Have you been qualified by numerous boards in New Jersey as a planner?
Yes.
Have you been qualified by this board?
Yes.
I'd like to offer him as a planner.
Questions? No. We recognize you as an expert in planning.
Okay. Did you review the part of this application having to do with the variance that's sought by the university?
I did.
All right. And what's the nature of the variance?
The applicant is seeking a D variance for a use that is not permitted in the zone, as well as a waiver for the separately designated loading spot.
All right. And in reaching an opinion about that, what did you do to investigate the matter?
I looked at the zoning ordinance, the master plan. I looked at the prior 4 resolutions. I examined the nature of the area and the use that's proposed by the applicant, and I was here to hear the testimony of the prior 2 witnesses.
All right. And based on all of that, did you reach an opinion as to whether or not this D variance should be granted?
I did.
All right. And first of all, tell the board what your opinion is, and then tell the reasons why.
Okay. My opinion is that the statutory criteria for granting a D variance have been demonstrated, and that a waiver is justified for the loading space. Perhaps I could pass out a 2-page handout that might be helpful. I don't see a positive response.
Sure you can.
Well, sure, you can, you can pass it out.
Yeah.
Yeah, I'll go the other end of the board.
Okay.
Mr. Coakley, do you want to mark that?
Yes.
A1?
Mr. Steck, is there a reason that you can't get this to us earlier?
There is no reason why I couldn't get that to you earlier.
Is this a technique?
It's,
You don't have to answer that.
Thank you. The reason may be that it's fairly self-explanatory. Let me describe what it is. It's a two-page handout that I prepared on September 3rd. The first page has an aerial photograph from Bing Maps, where I've outlined the subject property. Below that is a portion of the zoning map to the lower left, and to the lower right, the boundary line of the Montrose Park Historic District. On the second page are photographs taken by me on August 14th of 2013 that I believe accurately depict the existing conditions. Just to lay some foundation, this is an existing building that was, according to some records, built about 1910. It was initially a dwelling, but for many of the past years was used for non-residential use. It's an interior lot, and there's been some discussion already about the nature of the variances. In reviewing the variances, the last one was in 1994, but the variances that granted non-residential use for this consistently made two observations: that the area did have a frequency of professional offices and commercial uses, and the decisions of the Board of Adjustment consistently said that because of the nature of traffic on South Orange Avenue, it was not suitable for single-family residential use. The applicant, as you know, simply wants to occupy the entire building for PR and financial offices associated with Seton Hall University, the main campus being located right across the street. The applicant has restriped the parking lot to make the spaces clearer, and there are only minor modifications to the building, meaning cosmetic improvements. The surrounding area is pretty well depicted on the first page of my exhibit, and as the board has already explored, if you face the property on South Orange Avenue and move to the east or to the right, you have a parking lot, you have the health center, offices for Seton Hall, and then across Terrell there was the vacant building talked about. As you go down Terrell, there is a multi-story apartment building and then a series of single-family detached homes. If you face the property to the left, there is a professional office building which is all medical offices, and then on the corner of Warren Court and South Orange Avenue, there is also a dentist's office there. If you go further to the west, there are some residential uses, some office uses, and then there is an Institute for Judeo-Christian Studies that's associated with Seton Hall. The master plan recommended that this be in a R60 zone. There is a reference to the fact that it is in a historic district, although that is not reflected in a local ordinance, but it is on a district that's on the state and national register. I note that in your planning board documentation, this building is labeled as non-contributing, and it was indicated as it was severely altered from its vernacular style. So that means that it's ugly compared with, I think, the rest of the district. Also, it's really on the perimeter of the district and clearly influenced by some change uses along the way. This is in an R60 zone that does allow single-family homes and professional offices as a conditional use, but they're intended to be in buildings that people also live in, because you're limited to like half of any one floor. So the idea was that in this zone, when you had a single-family house, there might be a doctor or a dentist or a lawyer who presumably also lived there. But the baseline for this is really the series of variances, because they have really functionally altered the zoning. So this building has been approved for many years for non-residential use. The latest use talked about medical uses on the first floor, and it talked about daycare and offices on the second and third floors. In my opinion, there are statutory reasons why the board can grant this application. First of all, because this is these offices are associated with Seton Hall University, it is a component of the parent inherently beneficial use. There's a Princeton Medical Center case that talks about how you evaluate that, and you look at what is the nature of the use, the functional relationship to the parent use, and the need for some kind of proximity or relationship. And already it's indicated that indeed this is a function that essentially all universities have. They have to handle their investments. They do public relations. They're components of all major institutions. And because there is an interaction with other personnel on the campus, it's important that it be proximate, although it is not the same proximity that you need, for example, like a student center or the like. So in my judgment, this does share the inherently beneficial status of the university. Hence, you follow the SECA criteria for judging the merits of the use variance, that parenthetically you don't have to show peculiar suitability. Though that four-step process is to identify the nature of the use, the magnitude of the public benefit. I note that education is automatically a benefit to the general welfare. In my opinion, because there is no substantial alteration of the building or the parking area, because there is more than sufficient parking in terms of the number of spaces, even ignoring the garage space that's simply not needed, because there's been testimony before me indicating that the traffic generation would be less than the prior approved use, and indeed because even though you might say that there is an interest in having professional offices rather than general offices, as indicated by Ms. Dolan, the traffic and parking demands for a medical office would be more severe than is proposed. So in my opinion, the positive criteria are automatically satisfied because of its association with Seton Hall University. There is going to be no substantial change to the layout. It clearly has worked adequately for a number of years. And because the intensity is going to be less than the prior approved use by this board, and because this board on several occasions indicated that the permitted use is not reasonable, it has consistently concluded that this is not a suitable site for a permitted use, essentially a single-family home. In my opinion, that does constitute automatic special reasons, and that this board can approve it without substantial detriment to the public good and without substantial impairment to the zone plan and zoning ordinance, again, given the inherent benefit of this use to the university educational component. With respect to the loading area, in my opinion, it would be a waste of pavement to have a separate loading area. It is infrequently used. As indicated, the mail goes to a central location, so essentially it's a van delivery that is controlled by the university, so that, in my opinion, it is a waste of pavement to have a separate loading space for something that's infrequently used and will use essentially a vehicle that can park in a standard parking space.
All right, so that pretty much sums it up, and is there anything you want to add?
No, that pretty much sums it up.
Okay. No further questions.
I had a question. The issue of inherently beneficial is always something that's vexed me because everybody claims it. Does anything ever become inherently beneficial light, like an adjunct professor, where they're helpful, but you don't really need them, and they do it for free because it enhances their professional reputation? Is there? It's actually a serious question of the peculiar suitability seems a stronger argument in this case than, is everything that goes along with the university, do courts consider that inherently beneficial? You have a caterer come, are they now inherently beneficial? Where does it end?
Well, there's, let's say there's a sliding scale in general. At the top of the inherently beneficial use is the Regional Head Trauma Center in Wall Township, I think. There's a case that says the storage of school buses is inherently beneficial, but I would say that is the low end of the spectrum. The medical center at Princeton case instructed the board of how to judge where, in that case, Princeton Medical Center purchased a house in the middle of a single-family area and started using it for offices, and the court instructed the board how to evaluate it. In this case, even if you assume that this is not an inherently beneficial use, and let's say I had the higher standard of a Medici standard to show that I have to show it's particularly suited, I think we meet the test. The board has already concluded that permitted uses in the zone are not reasonable. On several occasions it said this is not a site for a single-family house. So that constitutes extreme hardship on its face and constitutes a special reason. I think that it is peculiarly suited because it has a history of office use, and indeed there was daycare use approved on the second floor. So I don't think you need to even find, frankly, that this is an inherently beneficial component of the university in order to find that the statutory criteria are satisfied, if that makes you more comfortable.
Well, yeah, it does make me more comfortable, but I'm still... So you even agree that there's kind of a sliding scale on inherently beneficial?
Yes.
Yeah.
I think the court cases say that. And again, it's a balancing effect. If the greater the public good from the use, let's say a hospital, presumably the more a neighborhood could tolerate traffic and noise from ambulances and the like. But there still are limits. There's a recent case where someone took a one-family house and I think converted it into 2 or 3 units for homeless. And even though that was acknowledged, I think it's called Salt and Light, if I remember, but even though that is clearly an inherently beneficial use, the court concluded that it did too much damage to the single-family environment, and so it didn't meet the balancing test. So there's an element of how beneficial is the use, and then that is weighed against its adverse impacts.
Thank you. We have other questions? Mr. Parlapiano.
Can we talk a bit more first about inherently beneficial? In this case, the university has a dedicated zone that has been designed to meet the needs of the university. And in prior cases, in fact, in the case that we approved the resolution earlier tonight about the parking deck, one of the key point that was made by the university was for granting that variance was the desire to keep activity on the campus, right? And we spoke a lot about the constraints of that zone, that, you know, there's, that they're pushing up against the boundaries of it. And there's a recognition that there's only so much you can do there, and so we need to build a deck now that, you know, this is the final swing at a parking deck on that site. And you know, because it's a constrained zone, but it's a zone that was designed to fit the university. And, you know, I would go down the same line that you know, asking that what the chairman was asking about a sliding scale. But I would also ask, you know, you to comment on, you know, effectively we've expanded the university zone across South Orange Avenue into a block of property now that are becoming annexed to the university zone. And I do wonder in this case, given that there is a university zone, whether that in fact places any constraints on the university, or whether inherently beneficial just, you know, spills across that zone, and in fact everything's up for grabs.
I think that it is related, but in this case, let's assume that I was coming in with general offices not associated with Seton Hall, and you believe that I needed a variance because I'm not professional offices. I think this is already similarly justified because, again, I have less of an impact than the professional offices, and because the intent of having professional offices was really part of a residential unit. That's why it says professional offices. The lawyer lives in the house where he practices, so much the doctor. Since it is acknowledged that this is not suitable for residential use, I think it kind of breaks that standard. And that's why I think the board could comfortably approve general offices. I think, so what I'm saying is that even if this is not associated with a university, I think there are statutory proofs present. The fact that it is associated with the university, in my opinion, makes it a more attractive application. And there is, as you may have learned from prior applications, there is a very weak demand for offices. This building is clearly architecturally no longer going to be used for residential use. Yep. So it does have a component of simply reasonable use of a property. The university will obviously maintain it well, and indeed it's going to upgrade it.
So then let me just turn to the second part of your argument, which is that the series of 4 variants that have been granted have already acknowledged on behalf of the town that this property is not well suited for single family and is suited at least for professional offices. What's the argument? That's granted, right? There's we have paper in front of us, they're approved, they're there. What's the argument to say keep going and cross the next line to general offices?
Well, again, I think this is an unusual, well, first of all, the observation that this property is not suitable for single-family use doesn't apply to every property along South Orange Avenue. There are other properties that where the number of single-family uses are greater, and so the area has not changed so radically. But here I am sandwiched between a parking lot for what is clearly a commercial office building and a newer medical office building, clearly designed for medical offices. So I'm kind of sandwiched in between what is de facto a changed environment.
Yep. But speak about the issue of general offices versus professional offices.
Well, again,
what you're saying to us is the existing variances have acknowledged crossing the line from residential to professional offices.
For this singular property.
For this site. And you're saying, so therefore, why not go all the way to general offices?
Well, I'm saying that I think the restriction, the constraint on professional offices was intended to be associated with someone living in a house.
Yeah, but as you've heard earlier, at least, I think there's some sentiment on the board that professional offices are a category of use that has a natural break on it. Right. Now, there's something different.
There's a break in the ordinance because it says you can't occupy more than 50% of the floor area of a floor. So if this were a side street, for example, I don't think you could necessarily make the same argument. But this is a main street. The board has, on at least 3 occasions, concluded that it's not suitable for single-family use. And again, I think the restriction for professional offices went hand in hand with the idea that it's still going to be used as a single-family use, in part.
Well, clearly the variance that's been granted didn't, anticipated the whole building would be used as professional offices.
Well,
right? You're right to say that
the last
the ordinance has
uses,
that.
The last 2 reservations, or the last maybe 3 decisions have said, actually 4, no residential use at all. So.
Right, that's right. So that's been crossed, right?
Yes.
So, but there is a maybe unspoken, maybe spoken acknowledgement that there's some difference between professional office and general office. What's that distinction? And why should we be comfortable crossing that line?
I think the distinction, again, I hate to repeat myself, I think it was because it was assumed that the residential occupant would be practicing there. So it was, it is not unusual to have practitioners operate out of the house.
Give me an example of a general office that's not a professional office.
A travel agency.
A travel agency, right.
And insurance agency.
Well, insurance, I think, would be a professional, no? I'm getting the nod.
Not under the ordinance.
Right. So a travel agency.
If they exist anymore.
Yeah, I know.
Real estate agents.
My travel agency's in the cloud. I mean, I'm trying to, I'm trying to understand.
There are financial services, you can have a financial consultant, that's certainly a general office.
A real estate office.
A real estate office.
Correct, real estate office.
A real estate office.
Okay.
So what you're trying to do, Mr. Parlapiano, if I may read your mind, is you're
Thank
trying
you.
to imagine it could become something
What door
else.
are we opening up
Yeah,
here?
right.
And I think the argument you're making is that the series of variances have walked us down this slope from what is in fact intended in the ordinance for the zone, single-family residential, have walked us down the slope pretty far. And you're saying, why not make that next step from professional office to general? And I'm trying to get your insight into what that step means.
Well, I don't, each variance is on its own merits and doesn't set a precedent. I do think there is an aspect of this that is associated with the university. And while I think it gives the application more potency, it also means that there is a connection. This is an entity that's going to well maintain that property because it's right across the street from their front door. So I think that connection has both practical impacts as well as eases the statutory proofs that the applicant needs to demonstrate.
Under the Princeton medical case, did the court essentially say that someone could prove that their office use outside of their campus would be subject to a possible use variance?
That's correct. It simply set up the rules which I generally describe. What's the nature of the use? What's the relationship to the main campus? And is the parent use an inherently beneficial use? That was a hospital, and they had some financial activities, if I recall correctly, in a house that was essentially an offices. So the court set up standards that the board walks through, and that's what I tried to do here. This is a function that you would clearly not doubt if it was on the main campus. You would never doubt that that was part of the university.
And that's why the zone was created.
There is a connection to the university. There's a need for proximity because there's a interflow of, just for example, the mail is being picked up in the main campus and delivered to this. That is a proximity issue, and people can walk across the street.
Michael?
Yes.
One of the things, if you look at the zoning, is that the zones where offices are permitted, the B zones, all allow professional and what they either call it business. Of course, they don't call it general office because that would be consistent with the definitions. But and the only time that it seems to me that professional offices are singled out is in this situation where it's a professional office in a residence. That's where the differentiation is, because that's a permitted conditional use in a residential zone. So except in this case, because it's a residential zone, but there is no residence, what they're looking for is to be able to utilize this as general office. And I guess what I'm getting at is that, what we have to decide is, since the building is sort of set up as a office-type building, is there really a need to have a differentiation between professional and general or offices when the business zones that would permit this kind of use don't make that differentiation?
And I also think that it's hardly likely that if we grant this variance that it would ever go in any other direction. I think once Seton Hall gets the property and changes it into a business, I'm sure it's never going to go back. We won't be concerned about whether professionals just want to use it. Seton Hall is not in the professional business.
It's all going in the right direction.
That's
There's
right.
an owner now that is going to be a responsible owner. It's at the front door. There's a weak demand for other types of office spaces. you know, the answer is it's nice to have a building well-maintained along South Orange Avenue.
And that's what I'm saying, that I think it's going to be.
And to boot, there's less of a parking demand and traffic than professional offices.
Well, a doctor's office.
Mike, one thing that, I don't know if you're thinking this way, is I'm thinking, well, okay, they take this on. Well, what's their big plan? They're going to knock it down and knock down that building on the corner, and then they want to combine lots. Well, you know, they'd have to come back.
Yeah,
and,
yeah.
And then the town can always say no. And we said no to Seton Hall, and they fought us, and we won. And because that other application was different from this one. It was clearly in a single-family area. It was much more intrusive. So I hear what you're saying. I guess the only potential concern would be if Seton Hall sold it to some other entity.
That's right, because it runs with the property. Or if there's some use that Seton Hall could make of this that would be much more intensive, that would fall under the, you know, the general office category, that would keep it within Seton Hall, but it would suddenly become, you know,
a frat house.
I don't know. Well, there we go again, right? But no, I'm not thinking of frat house. I'm just thinking a much more intensive use, right? And that's what I'm trying to imagine is what might that be, right? Obviously, if it was I think the parking and traffic engineers talking about a doctor's office, 15-minute appointments, there's a lot more flow there. That's more intensive, and I guess that would be allowed as a professional office. I'm just trying to imagine what are we, you know, this runs for the next 100 years. What are we approving here?
Well, we're not approving retail.
Right.
The other issue is, I know that the board is only tepid about the idea of inherently beneficial use, but in my opinion it is. And if you go that route, you link it with the university. So you link the facts of the case with the fact that it is right across the street from a university use. So it's not that anybody, another general office can walk in.
I think Mr. Steck is correct. I think if the board rules in favor of this application, I think the condition of the approval would be for general office uses associated with the university or run by the university. And then that would put some limitations on the property. And then getting back to the difference between professional, as far as the parking goes, the prior approvals for the professional uses and the idea of professional uses in a residential zone, yeah, if you had a, you know, medical facility here with 10 doctors, you'd have a lot of traffic coming.
You'd have a lot of traffic, yep.
But this is limited to 3 professionals, you know, so, you know, I'm not disputing the engineer's traffic study. I don't disagree with that, and I think it's actually conservative because the report is based on gross floor area when, you know, even our own ordinance requires parking based on net floor area for this type of use. So I'm not arguing with that, but I think if the board is concerned that, okay, if you grant the variance for general offices, then sometime during, you know, down the road, Seton Hall decides to sell the property to someone else, then they can rent it out to anything else that would fall into the description of general office. Then the case that Mr. Steck is presenting regarding the inherently beneficial use of the property as being associated with the university kind of goes away. So that's something the board might want to consider. If you're going to accept the, you know, the beneficial use of the university on this property, then perhaps that's something that should be included in the resolution and included in the approval.
You think we could make that stick?
I haven't seen it, but it makes a lot of sense.
What kind of office would we be concerned about in the general office category?
Call center.
You know, it could, you know, there's
Because you have.
A huge number of people. You could have 40 people in there. You know?
I mean, there's...
Providing customer service for people in India.
There's any number of, you know, offices, you know, that can be general, you know, just general offices that are not considered professional offices by our ordinance. If somebody wanted to put in, you know, even an office for a taxi service, that's an office. You know, they would have to get approval to run the taxi cabs and park them in the lot because that's separate, but a simple, any simple office space, you know, other than something listed as a professional office might be considered general.
Thank you. Ms. Gruhl?
I would like to note that I agree with Mr. Steck that there is a variation or a level of how inherently beneficial something is. And I believe that you could make the argument that this is associated with the university. It certainly wouldn't be on the top 10 list of most inherently beneficial uses, but certainly there is an association with this and the university, which clearly is inherently beneficial. So, I can certainly understand that argument for particular suitability and the fact that it, as a inherently beneficial use, that it meets the positive criteria, then the balancing of that would be with any negative impact. And I think there's been a lot of testimony as it relates to particularly the parking and the traffic and its impact. So I would just note that relationship there.
Thank you. Okay, other questions? None? Do members of the public have any questions? Okay, thank you.
Okay, I don't think it's a long summation is necessary. You've heard the proofs. I think proof has been presented as to this variance, both from the standpoint of a particularly well-suited site and an inherently beneficial site affiliated with the university. In both instances, there are no negative impacts that seem apparent. We request that you grant the variance to allow the university to use this for office space in connection with the university.
Is there anybody from the public who wishes to speak? Okay. All right. Is that it?
That's it.
Thank you. Okay. We have any comments, questions?
I have a couple of questions.
Yeah.
I don't know who would answer them, but is any signage proposed as part of this application?
There will be a typical university sign that would indicate it as being a Seton Hall University.
Is that anything we need to address now, or is that a separate application?
If it's within the ordinances, there are ordinance for the signs.
They need to be part of the variance. There is an ordinance regarding ground signs, residential zones for these types.
So we don't have to address it now?
If it's conforming, to
Okay.
the ordinance's requirements, then there would be no issue.
Yeah.
Okay. That's it.
I wanted to make sure that Mr. Parlapiano's concerns are addressed, because he's very thoughtful about these kinds of things. And do you have any other questions for members of the board?
So this inherently beneficial argument feels to me like a bad slippery slope. And I think that in this case, we have a property that effectively stands on its own 2 feet, and you can make a strong argument for it independent of the university. And what I'm thinking about is that I'd rather do that and not reference the university. And my concern is exactly what I said, which is the university borders, when you surround the university, a lot of adjacent properties that have the benefit of being adjacent, that have nice lot sizes, that could probably park some cars. And I worry about that, right? We created a university zone to provide a special place to run a university within a residential community. And, I think the test is not, to the extent these are general offices, they could in theory go a lot of places, right? There is a lot of open space in town. The mail truck could drive a few more blocks. I think acknowledging this idea that inherently beneficial extends to administrative offices just because they're across the street, I don't think is a good idea. And I think this, making this case stand on its own 2 feet as a case about this property for this use keeps us cleaner on that issue. And I don't want this to come back in the future
in other cases about other single-family houses surrounding the university zone, as the university zone is effectively expanded out to cover more and more of the town.
I thought your questions were more concerned about other generic commercial offices. Now
Okay,
you're shifting it on us.
I have many concerns in life, I apologize.
So, I think that...
I think the questions about the other uses, I'm chewing on that. I'm having trouble coming up with an example of a general office use that would be more intensive than doctors, for example, or a large dental practice or something. So I guess I'm getting more comfortable on that front.
So, Michael, is what you're saying that you're less inclined to tie this to a university use as opposed to just a generic general office use, so that if the university sold it 10 years from now, another general office could move in? Again, is that...
That's what I'm saying. Full disclosure, I'm thinking out loud, but yes, that's what I'm thinking, right?
Okay.
Because
I mean, for me, I don't, for some reason, I don't have as much comfort level with tying it to the university use. You know, that would make that a restriction. I would think that I would be more comfortable if it was just approved for general office use, and it doesn't have to be associated with the university.
I definitely understand, Michael, where you're coming from, and I would tend to agree with you that there is the risk that it might, someone might get the idea that whenever the university, or a university for that matter, came to any property and tried to get a variance, that they would meet one of the conditions of a variance simply because they're university use. But I also recognize that there's a possibility that there are other uses that are non-university that could have an impact. And it seems to me that we could have the best of both worlds in this situation simply by setting up the conditions in such a way that you set it up where it stands on its own. You say because it would have lower traffic generation and it's a less intense use than the variance is already granted, but with the added benefit of beneficial use, which we could say in and of itself wouldn't stand alone to prove this application. And we could literally say that, and I think that would give you the best of both.
Yeah, well, you're sitting on the fence just like I am. And I was thinking about that too. I spent a career sitting on the fence and starting to get sore. That's my job. Yeah, there's an inherently beneficial light aspect to this, but you know, I am so tired of everybody coming before us claiming inherently beneficial, and many of them much less inherently beneficial than even this application. It's associated with the university, but it also has particular reasons, like Mr. Steck very concisely noted about its history as being professional offices and a daycare, and it's being not suitable for single family, both by its own interior modifications now as well as what surrounds it. So you kind of have a little bit of both there. You know, I am not scared of the inherently beneficial argument anymore, because we've appropriately, in a particular case, turned down Seton Hall, and in one case out of many, and it went all the way to the Supreme Court of this state, and they didn't want to hear it, but the other two courts, if not necessarily saying great job, said that it was reasonable what we did. So we can say no, and we can acknowledge inherently beneficial modestly, and we can say there are particular reasons. So you know, we could stew on this forever about what it potentially could be, but you know, that's a way to distraction.
I just want to point out that I don't know that there is a lot of office space available actually in South Orange, at least not renovated office space or moving office space. I think what was open in our largest office space in South Orange is now going to be occupied by the Village. And I mean, I for one would like to see more renovated space in South Orange, and the professional community to continue to uplift its appearance. I was thrilled when I saw that the building over Investor Savings Bank was redone, and I would like to see that more throughout the community. So in my shopping around recently, I'm not finding a whole lot available, and I'm not finding a whole lot available that I would bring my clients to. And I'm not getting responses from some of the landlords, I think because they're full. I'm following up, and they're full. And I just don't think that this argument that there's a lot of office space is accurate. I know the one across the street that we're going to be hearing soon is an issue, but besides that, I don't think so.
I'm missing your point as to this particular.
Oh, because I've heard at least 3 times tonight or 2 times tonight that there is a lot of office space available. And I just am arguing that factual representation by members of the board. I don't think there is.
That's still good information, even if you hadn't heard that, but it'd be better if we heard it as testimony from the applicant.
We have other questions or concerns. Anything down there from the other end? Mr. Adler, Mr. Shapiro, anything to, you don't have to say anything, but are you waiting?
I think, let's suppose Seton Hall did not buy this property, it was another person. Would it have been a concern? Yeah, but if there was a concern, I think that Seton Hall, coming forward and doing what they're doing, I know a little bit more about the property. The owners of the property moved or ran away to Melbourne and left the property. So I think that Seton Hall coming and stepping up to the plate is probably doing us a favor.
I think we've mentioned the positive criteria about the modest, inherently beneficial, and the suitability of this particular space, given its history as well as its site, but also the negative criteria, in that this will traffic will generate less traffic than a typical doctor's office, and it's already set up as an office space. So the negative, I don't see negatives to this particular application. It's
and I'm assuming that we would write this so that it supersedes the 4 previous and clean that history up here, yeah?
I don't think that's justified.
I'm sorry?
I don't think that's justified, that you would write this and supersede prior variances. I mean, if Seton Hall can't use it for its own use, they would want to go back to the prior use. It's non-residential, we all know that. Why would we supersede justified prior variances? I mean, I think what we may be losing sight of is that Seton Hall bought this property in light of its condition, in light of the fact that it had been used in this way for many, many years. It's not like we're advancing into a new neighborhood. And I think even under the prior application that the chairman adverted to, there was advice that Seton Hall ought to go to these vacant buildings.
I mean, I think in some ways this is, as this area is developed, this is about as good as you're going to get. And I'm not saying that in a backhanded compliment. I think this is as good as you're going to get for this particular site. I don't know what else you're going to want that's better. Mm-hmm. You're not going to get a single family that's going to move in there. So. All right, any other questions? Ms. Gruhl?
Just a comment. I'm somewhat surprised that I heard, I have been in many applications where the previous approvals have been part of conditions extinguishing those previous approvals. So I don't find that an unreasonable, as long as the applicant agrees, an unreasonable condition that I've seen imposed by other boards once an application, subject to approval, obviously, of whatever the application is in front of the board. But I just note that.
you know, if we did approve what's been requested and it's general office, I guess the one piece, if you superseded, that'd be lost would be the child care, which wouldn't be allowed under general office. But the other office uses, I'm assuming, like, you know, professional office would still be permitted, right? But what would really be superseding is a daycare or childcare.
Well, do we particularly have?
We'll agree to supersede childcare.
Good. Okay, so we got those tots off the table now. Damn kids. All right, what else? Mr. Rinda? Anything else? Okay, so they're agreeing to take the, abandon the daycare, or I don't know what the legal term is.
Whatever was allowed in that variance.
Yeah. And there's any other condition here?
Office, not classroom use.
Office, not classroom use. Is there any other?
So this previous case, 845, if they were abandoned, previous variance.
I'm not sure which one it is. Is that what it says, the daycare?
Yeah, 845.
Okay, then it's 845.
Just Christian daycare.
Okay.
Oh, wait a minute.
Okay, so then may we have a motion?
You know, I don't know if it was Bill or Todd, but somebody had this kind of way you expressed it about not leaning on the inherently beneficial, but if you could try to re-say that, I think that, to me, that was the best formulation that I heard.
You know, it's interesting. I'm not sure if it can be worded correctly in the resolution, but in the discussion, it's certainly there. And so the resolution can put it in there without it being a condition necessarily. But it's, you know, the motion would be to approve the application because of the elements that it stands on its own. It would reduce, recognizing that it would reduce traffic over the previously proposed or approved uses, and that and because of that, that's an inherently beneficial use in and of itself. That it improves on it has a positive impact to the town.
Right, it's a beneficial use, not inherently, but it meets the test of being beneficial.
Right, it's beneficial use. Right. And in addition to that, the Seton Hall, the fact that it's connected to Seton Hall University adds to that, where it wouldn't necessarily stand alone, but it is an added beneficial use. And with the condition that as proposed by the applicant, that they would abandon the previous variance for daycare center.
It's aligned with an inherently beneficial use.
That's it, right?
I'm sure that will hold a lot of water.
So that was, that was case number 845 for reference.
To the extent you captured that, I'll second it.
I'm sure that our attorney will
Are you clear?
I think I have it.
Okay. We have a vote?
Mr. Don?
Yes.
Mrs. Escala?
Yes.
Mr. Polipiano?
Yes.
Mr. Reeves?
Yes.
Mr. Semper?
Yes.
Mr. Aller?
Yes.
And Mr. Shapiro?
Yes.
Okay, very good.
Thank you very much.
You're welcome. Okay, I'd like to take a brief break between 5 and 10 minutes, and then we are going to move on to Dr. Singlet this evening.
We've been waiting for it. We don't even have a choice.
Okay, we're back in session. Okay, the next case we're going to hear is Rucci Realty LLC and Dr. Sandy Singla, DDS, MD. This is 63 Valley Street. Good evening.
Good evening, Mr. Chairman, members of the board. My name is Kevin Hahn. I'm the attorney for the applicants, Dr. Singla and Rucci Realty. Parenthetically, that was a typo on the charter, but unfortunately, that's the way it was recorded. Rucci Realty LLC. It was supposed to be Rucci Realty. In any event, I represent Rucci Realty owns the property. Dr. Singla is the sole managing member of Rucci Realty and also the oral surgeon who's going to, if you approve his application this evening, going to occupy the premises on the first floor as an oral surgeon and then rent out the 2 offices upstairs. As you know from the application, this involves 63 Valley Street. My client currently practices at 71 Valley Street, a few doors down on that corner building where he also is on the first floor of that building, and I'll have him explain why he prefers that in his practice. Also with us tonight is Drew DeSessa, who is a professional planner as well as a professional engineer. He's going to offer some testimony as well. Unfortunately, the architect is not here. He was available last month, not available this month. I don't think we're going to need him. Dr. Singla will be able to answer the questions you had concerning landscaping and some of those other items, signage and what have you. So I don't think we'll need the architect. You have his renderings. Those were really submitted more for informational purposes, just to show that Dr. Singla intends to improve the property, the exterior of the property. He's not changing the site in any way, but he is changing the facade and adding some brick and stucco and so forth, obviously bringing it, improving it beyond what it, I guess it was sitting there vacant for the last 4 years, and it's in pretty rough shape, so, obviously he intends to bring that up to current standards. So with no further ado, I'll have Dr. Singla sworn. I'll have him give you the overview of what he intends to do with the property, and then we can hear from Mr. DeSessa. Sandy? I just stand over here.
Please raise your right hand. Do you swear or affirm the testimony that you give here this evening is the whole truth?
I do.
Please state your name and address.
Dr. Sandeep Singla, Singla, 34 Tiller Road West, South Orange, New Jersey.
Oh, by the way, before I start on that, I should indicate, obviously, the application, as you know from your professional planner's report, it includes a request for a D variance to have a professional oral surgeon office on the first floor, where in the B1 zone, professional offices are only allowed on the second or higher floor, and also a C variance because of the parking issue. We have 8 off-street parking spots available at the property, whereas based on the net floor area, 10 parking spaces would be required. So that's the relief that we're seeking this evening. Anyway, Doctor, would you tell the board where you currently practice and when you purchased the property at 63 Valley and what your intentions are with respect to that?
Well, I've been in the town of South Orange for approximately 7 years. I practiced as an oral maxillofacial surgeon, originally on Irvington Avenue, 177 Irvington Avenue, after which time I shifted over to 71 Valley about 2.5 years ago. Both of those locations were smaller, and thanks to the grace of God in this town, I've been slowly increasing my practice. And in December, I opted to purchase 63 Valley. From what I knew about the history of that building had been empty for about 4 to 5 years. One of the primary reasons I purchased that property was because it's one of the very few locations that actually has on-site parking. Unlike other offices, as an oral surgery office,
We have scheduled patients, usually 1-hour appointments. There's not a whole lot of foot traffic that happens in the office, but most of my patients are put to sleep. So from a safety standpoint, I preferred to have some on-site parking for my patients, and that was a rationale for me purchasing this building. Later, I found out that there were some zoning issues in terms of what is possible on the first floor versus second floor, and that's when I decided to get some guidance in terms of getting the appropriate variance to be able to open the office on that first floor.
Now, Dr. Singlet, you currently are on the first floor at 71 Valley, correct?
I am. I'm currently on the first floor at 71 Valley Street.
Right, and you were talking about your patients and safety concerns. Is it also a concern of yours that when they're sedated, you don't like them walking up and down stairs after they had a procedure?
Yeah, that's correct, and that is my rationale for trying to occupy the first floor rather than the second floor, which is a permitted use for professional office. I think from a safety standpoint for my patients, it is beneficial for them to be actually on the first floor and walk outside to their car rather than going down the stairs or an elevator or whatever the case might be.
And currently at 71 Valley, is there any off-street parking associated with that building?
There is not.
Okay.
So right now, although we are requesting a variance for the parking, from my standpoint, we'll have a less of a demand on the on-street parking because we will be providing off-street parking for the patients that we see.
Yeah, do you and your staff and your patients currently either park on the street or in the municipal lot that's behind 71 Valley?
That is correct. That is what is done as a general rule.
Okay. So in your view, if the board approves your application tonight and you add these additional 8 parking spaces, obviously your staff and you and your patients will have less of a demand for the on-street and the municipal lot because you'll have 8 spots that you're providing.
That is correct.
Okay. Now, with respect to, you saw the report that was issued by the by the board's professional planner, correct?
I did.
And she had certain questions about the parking, which I think we addressed. We can address that a little bit more. But she also had some questions about signage. Do you remember that?
I do remember that. And my plan for the signage, although I don't believe the architect has done all the drawings on the signage, my plan is to follow all the rules and guidelines that are currently set forth by the town of South Orange and put in signage accordingly.
Okay. So you're not looking, in terms of signage, you're not looking to do or to erect any signs that would not otherwise be permitted under the ordinance, correct?
That is correct.
So if the board, again, approves your application tonight, you fully intend to comply with all the signage ordinances?
That's correct.
And you understand that if you wanted to put up a sign that was not permitted by ordinance, you'd have to come back here and get approval, correct?
That's correct.
Okay. Also, the planner asked about more information concerning landscaping. Could you just briefly tell the board what your plans are with respect to landscaping the property once you've completed construction on the exterior facade?
Well, I think in terms of the landscaping, as I'm sure a lot of people here at the board knows, that building, because it has been empty for so long, the property has deteriorated on the outside significantly. So in terms of the landscaping, we will have a rendering done in terms of the outside. The plan is to do exterior work on the building that will include a brick facade on the front with stucco on the other 3 sides. And then from a landscaping standpoint, get rid of all the weeds and either do sod or with some shrubs or pavers. I think that's something that's going to have to be put on paper and then get the approval in order to do the appropriate landscaping. But certainly, this is a doctor's office, so the building has to be presentable both from the outside as well as the inside.
Right, so it's fair to say that you're going to upgrade it from its current condition?
Yes.
Okay. And I don't know if the planner may have further questions on that, and we'll be glad to answer them. And then also, the planner had asked about lighting. Is there lighting currently for the rear parking lot that's on the building?
Right now, there are exterior lights on that building. There is a total of 3 light fixtures that are on the outside rear exterior of the building. There is 1 floodlight on each side of the driveway, both on the left and right side of the building. And then there are 2+1 floodlight in the front of the building. You also do have, because it's abutting the parking lot, you do also have spillage of light coming onto the property just from the parking lot itself. So I think once all the lights are on, it's actually pretty well lit in terms of the exterior lighting.
Now, so is it fair to say that you intend to leave the lighting that currently exists and not change it?
That's correct.
Okay. Also, the planner had asked about, there was a door, I guess, there's 2 doors shown on the front of the building currently, or there's 2 doors that exist. She had a question whether another door was going to be added on the right side of the building, or whether that door was going to remain there.
There are currently actually 3 doors on the front of the building, 2 doors on the back of the building, and all of the doors, the exterior is remaining exactly the same. So there will be no change to the doors itself.
So no doors are being added?
There is not.
Okay. And with respect to repaving the driveways and the parking area in the rear, have you come to any conclusions with respect to whether or not that's necessary?
I have walked through the parking lot multiple times. There is no potholes. It is pretty even. There's a little bit of a slope, but I think that's just the physical topography of the land. There is no potholes. There's no cracks. I think it's actually a pretty decent driveway. So at present, there is no plans to do anything with the driveway unless it's a condition that the board imposes.
All right, so you'll address that as needed?
Yes.
Okay. And lastly, I just want to go back on the parking issue. I think you touched on it, but I just want to have it clear so the board understands. With respect to your practice, unlike a general dentist, what is, in terms of the use and parking spaces, the intensity of your use, at any given time, how many spaces do you require for your practice?
You know, I would say for any given space, you would have 1 designated spot for the doctor. You would have 2 designated spots for the 2 staff members that are there, and then 1 to 2 spots for the actual patients. Typically, we have 1 car at a time for the patient. If there is an emergency that comes in, then you'll have a second patient that comes in. This is not a doctor's office where they're seeing patients every 15 minutes or every half an hour. This is not a dentist office where they're trying to see 3 patients in 3 different chairs. As a surgical office, as a surgeon, where you have people asleep, you need to be dedicated to that 1 patient. So really, we're seeing 1 patient at a time, with maybe the possibility of 1 patient waiting if it's an emergency or something like that.
Okay. I have no further questions of Dr. Singler.
Okay. Who on the board would like to start? Mr. Shapiro.
What are your typical office hours, Doctor?
This office is open Monday, Tuesday, and Thursday from 9 to 5.
Thank you.
Mr. Super.
Do you have other offices that you go to, so in the state?
Yeah, I have multiple offices, which accounts for the reason why the office is only open 3 days a week. I have offices located in Wayne, New Jersey, in Newark, New Jersey, in Waldwick, New Jersey, and hopefully another one in Roselle, New Jersey. So.
Now, by the way, do you know, are you the only oral surgeon currently practicing in South Orange?
I am the only oral surgeon in South Orange presently.
Sorry.
Can I, just a couple questions about the building.
Sure.
So there are 3 doors on the front.
That is correct.
Where do the 3 doors lead?
Sure. From what I understand, originally this was 2 retail stores on the first floor, and then the center door was up the stairs for the left and right office spaces that are built.
Right, and you said you're going to keep those 3 doors?
Yeah, so the center door will remain for future tenants that would be upstairs, and the right and left doors would be used for patients to come in of the office. 1 door would be for the reception area, and then the second door would be used after the patients have had their procedures to leave out, so they're not actually drowsy and walking in front of a patient that may be sitting there.
But, sorry, not to interrupt, but The drawing that you gave us shows that the center door is the door that you enter to get into your office as well as to go up the stairs.
Yeah, that part, what the original plan was, is to use the center door where that would be sort of like an air barrier, so you would cut a hole where the stairs are to enter the space. But that has since been modified by the architect because of wall space issues and impinging on the size of the reception area.
So the left door is going to be the door into your reception area?
That is correct.
So it'll just go straight in?
That's correct. So
And the right door is the door you sneak in when you're late for your office hours?
Well, that would be the back door, because there is a door in the back where the parking lot is, so.
So the right door is just...
Well, no, the right door would be, that door would be utilized by the patients to leave after they've had surgery done, so that way they wouldn't be going in front of the reception.
Which door, the back door?
Either the back door or the second door, the right and left door.
But then they're going through your office to get to that second door at the
Yeah,
front.
that's not really going to be my office.
Well, then, don't take this the wrong way. With all the changes on the plan, what's the use of us looking at these plans?
The interior is sort of a preliminary plan because we're trying to get the variance, and then we'll have once we apply for the actual construction permits and everything else, then you'll have a more accurate flow of patients inside of the office itself.
Okay.
Is it still accurate that you're going to have 3 treatment rooms?
It is accurate that we're going to have 3 treatment rooms.
But one doctor?
But one doctor, yes.
And so at any moment, you'll use at any hour, you'll use one room?
That's correct, because at any given time, you're only seeing one patient. Now, the reason for the second and third rooms, for informational purposes, what happens is, if you have an emergency at least, you can get the patient into the room, give them an injection or something while you're treating your scheduled patient. The third room really becomes utilized about 10% of the time when you have somebody that is asleep and your next patient is here. You have a registered nurse that will recover that patient while you're starting treatment on the next patient.
Do you know anything about the history of this building in the 4 years that it was supposedly vacant?
Well, I was in negotiations with the previous owner for about 3 years in trying to acquire this building. Prior to that, it used to be a Rapid Press, almost like a FedEx or a Xerox copy center on the first floor. And on the second floor, I believe it used to be an accountant and an attorney.
And right now, the building is currently vacant, right? Totally vacant?
It is not totally vacant. There is a tenant on the second floor.
Oh, okay. That's since I've been there. Last time I was there, it was still vacant. I apologize for that.
Ms. Gruhl.
Yeah, I have a couple of questions for verification and such. Can you explain the second floor tenant and where they park and how that would affect, how do they get in and out? And
The second floor tenant would go up to their space using the center door, which again is not connected in any way to the first floor. So there is a little vestibule, then they would go up the stairs into the second floor space.
And then where would they park, was the question?
And in
Park
terms
their
of
car.
Right, in terms of parking, they would park in the parking lot. There's a total of 8 spots. It is a taxi dispatch. They have 1 car, so they would park on site at that spot.
And just to follow up on that, Dr. Singler, do you anticipate that each tenant upstairs will each have 1 designated spot?
That is the plan, yes.
Okay. So if they each get 1 spot and you're using 4 or 5 spots maximum, that's roughly 7 spots at any given time.
That's correct.
So there are two tenants upstairs
Well, right now, currently one, but there's another space for another tenant,
that is not occupied at this point?
not currently occupied.
That
Correct?
is correct.
Okay. And what's the square footage of the upstairs?
The upstairs is 750 on the right-hand side of the building and 800 on the left-hand side of the building.
And which space right now is occupied?
The 750.
Okay. And that's the taxi dispatch?
Correct.
With one employee, correct?
Correct.
And a taxi cab?
That is, well, the taxi cab is their primary car, they only have.
Right.
But yes.
I'm
Yes.
just trying to clarify.
That is correct.
Okay. And then I gather that these floor plans really are not, and the way that some of the elevations are not necessarily accurate anymore, correct?
Correct. I'm sure they will be updated based on my desires, based on what I think the office should look like, based on my professionals that are actually going to design the office itself. What I had them do just to give the board an idea of what the inside would look like, I had them do a preliminary rendition of the inside of the office.
I guess the only relationship that I would be somewhat interested in are the access points, the doors and the windows and whatever would be on the outside, and whether there would be any change to that.
There would be all of the floor plan on the inside may change just based on size of certain equipment, but in terms of the exits and entrances of the building, they would remain exactly the same as they are now.
So, okay, so your testimony is that the outside in terms of the facade, the frontage, will remain as it is
Identical.
existing, obviously without the boards and,
That's correct.
everything else.
That's
Okay.
correct.
And then the other is that you noted that you will comply with the signage
That is correct.
ordinance, so that the elevation that you have with respect to that is not in compliance.
It is not.
And so
That is
you will
correct.
be in compliance, your
Yes.
testimony?
Yes.
Okay. In terms of the lighting,
Yes.
I don't know, you noted that there were a number of building-mounted spotlights, lights.
That's correct.
I have no idea, but are they shielded so to the extent that there's enough light, but then, again, you want to make sure that there's no glare and spill at the same time? So are they, I don't know, but are they shielded lights, or is there glare?
Honestly, those lights have never been on, so I can't tell you whether they're shielded or not shielded. What I did was I counted the number of fixtures that are on the outside of the building currently, and those numbers reflect those fixtures. Certainly, if the board grants my application, then I will make sure that those lights are functional.
If you look at the photos that are in the planner's report, they're not shielded.
I suspected that that was
They're
the
floodlights
case,
mounted on the side of the building.
But it's, and the other thing that we did not note in our memo, but when looking at photos and visiting the site, where would your garbage and recycling be? And is it proposed to be fenced in, screened?
Right now, the garbage is actually in the rear of the building, next to the air conditioning unit, I think, in locked garbage cans is where it is or has been placed in the past.
Just laying, a photo I see has some black bags that are out there and just garbage that's open. So normally that would be something that may require some more screening for your own purposes as well.
Okay.
I just note that. And the landscaping, would you be Would you be preparing a landscaping plan that would then be submitted to this board or the professionals, or?
I would be submitting it to the town for the landscaping permit, so they would then get a rendition of what the landscape would look like and proceed further. Certainly, the building needs landscaping, there's no issue about that, and something will definitely be done to improve it from what it is.
Thank you.
You have on here the upstairs. It says existing office, existing office, existing office, and a lavatory that's separate from all of those. You're saying this is not the way it's going to look?
No, that is, the upstairs will look exactly like that. The only change, because that is all pre-existing space, the lavatory is in a common area, so once you go up the stairs, you have a common area where there's a lavatory, which both tenants would use on the left and the right-hand
Tenants would
side.
share that lavatory?
That's correct. On the second floor, the two tenants would be sharing that lavatory.
Is that legal by code? Okay.
Yes.
Then there's a egress for the tenants upstairs to leave by the back door, if I'm looking at the stairs.
That's correct. There's actually two sets of stairs to go to the second floor. One through the front of the building with that center door, and then there's also stairs in the back of the building that are enclosed via the parking lot, and they are able to get upstairs that route as well.
So, Ms. Gruhl, what was it, the things you had concern with, the lack of specificity on the screening of the lighting, and what else? The garbage.
The garbage.
Do we care, and this is for Mr. Don too, about the office space that he says he might move around a little bit? Is that really relevant to this particular application?
Is it relevant? Probably not. It's just, if it's not relevant, then why submit? Don't submit a plan and then tell us that's not the plan. It's just a little annoying, that's all. Because it's helpful to understand what's going on inside, to get a feel for the intensity of the use. I think he's done a good job of explaining why he has 3 rooms. It just is a little confusing when you ask questions about the 3 front doors, and then it's, the use of those doors doesn't match up to the plan that you're looking at. So, but I think in the overall, it's not a big issue.
Ms. Gruhl, you think it's?
Yeah, I think that the applicant has testified as to what I was concerned about was what the facade and how the front facade would be viewed, and whether there were changes to that. And that could indirectly be influenced by the way that the interior is designed. So if the applicant is saying that it will remain as it is, well, then it will remain as it is.
That's correct.
And that's what I was concerned about, was whether that was a moving target or not.
The exterior windows, exterior doors, everything is remaining identical.
And then the properties on either side, Dr. Singla, there's a consignment boutique and Papillon, the restaurant?
Correct. I've met with both of those property owners, business owners. They actually would be very happy to have me there and beautify that building a little bit more than what it is right now.
And Ms. Gruhl, this is in the B1?
Yes.
Yeah, B1. Okay. We have other questions? Dr. Singla? Mr. Adler?
Doctor, you said you had 4 other offices?
That's correct.
Wayne, Waldwick, and what were the other 2?
Wayne and Newark.
2 in Wayne?
No, 1 in Wayne.
Wayne?
1 in Newark.
Newark?
Yes. Last one in Roselle.
Okay. And are all of those offices no steps to get into your office?
The Wayne office has steps, but we actually built a handicap ramp on that, in that building, so we would have handicap accessibility. But all of the other locations have no steps, first floor. Even the Wayne office is a first floor space.
But you can't get in from the ground level, right?
Right, there's 2 steps, so we built a ramp, so that is correct, but it is still a first floor space.
'Cause when I'm asking, I'm having trouble with your testimony that, and you probably have an answer for it, but I want to bring it up, that you want to be on the first floor because your patients are sedated, and you want them to walk out to their cars rather than downstairs. I mean, these people are going to drive?
No, they're not going to drive. They have a driver with them. Legally, they can't drive because they're half drunk, but they still have to get to their car. Whatever me as a professional can do to try to minimize the risk of them falling until they get to the car, I feel that is my obligation to do.
So they do all have drivers?
Absolutely, 100%.
Okay. Is there any special biohazard waste that you have to be concerned about with trash or anything like that?
Well, we have a company, Stericycle, that comes in and takes care of all the sharps and biohazard materials.
And where does that get? Where do you plan to store that for this facility?
That is all stored inside of the building itself. It's not placed outside.
Okay, and if the tenants upstairs need have somebody visit them, where is that person to park?
On the street. That's where they would park if they were going anywhere else in South Orange.
Okay.
Mr. Shapiro.
Doctor, you earlier testified that one of the principal reasons why you want to locate your offices on the ground floor is to prevent having patients who are drowsy after anesthesia having to go up and down stairs. Yet I don't see any plans for a ground floor lavatory.
No, there will be, on the first floor, there will be a ground floor lavatory.
There will be a lavatory?
Yes, absolutely.
Okay,
Absolutely.
thank you.
Yes.
Sorry, one other question. There's an existing ground sign that's out there at this point. Are you planning on eliminating that or using it or?
I have not yet made a decision on that.
Okay.
What is this?
The ground sign that currently exists in the front yard, whether that would remain or be eliminated.
You have several offices. How many days a week do you plan to be here? Or are there going to be other doctors in your practice working here?
I do have other doctors that work for me, but between myself and my associates, we would be planning on being in South Orange 3 days a week.
3 days a week.
Which is the current schedule that I maintain in South Orange right now.
Okay.
And those 3 days, as you said, Monday, Tuesday, Thursday, 9 to 5?
Correct.
Is that correct?
Correct.
We have other questions?
I just wanted to clarify, and I apologize if I'm making you repeat something, but you said that you're not going to change a lot of the exterior features, but the plans are all showing a brick facade.
Yeah, that's what I'd like to do, actually, and what'll happen is for the exterior, we'll have separate drawings that will then get submitted to the town for appropriate permits. My goal is to have a brick facade in the front with stucco on the other 3 sides of the building. We would still maintain the same doors and the same windows, but I would like to take off that siding. I don't think it blends in very nicely with the rest of the buildings in the area. So,
Yeah, if it did, then we'd want to get rid of all the buildings.
Other questions? No? Okay. Do members of the public have any questions? Okay.
thank you.
Thank you. I'll call Drew DeSessa at this time. Mr. DeSessa has not appeared before you before. He's obviously appeared before other boards and represents boards. I have a copy of his CV. I don't know if anyone's interested. I brought some extra copies. If you want to look at it while I qualify him, that's up to you.
You can pass the CV while we're
Sure.
qualifying. You can mention the highlights orally.
Does he have to be sworn?
Yes.
Yes.
Would you raise your right hand, please? Do you swear or affirm the testimony you'll give here this evening is the whole truth?
I do.
Please state your name and address.
Drew DeSessa, 3 Ridgely Street, Hackettstown, New Jersey.
Mr. DeSessa, would you give the board the benefit of your qualifications to testify as an expert?
Yes. I have a Bachelor of Science degree in Civil Engineering from Rutgers and a Master of Science in Engineering Management from NJIT. I am a licensed professional engineer in New Jersey and Pennsylvania, and I'm a licensed planner in the state of New Jersey.
Okay. And do you have boards that you represent?
Yes, I represent the Township of Mansfield as the Township Engineer and the Land Use Board Engineer and the Zoning Officer.
Is that the only town you represent?
Currently, yes.
Okay. And have there been other boards in the state of New Jersey that you've appeared in front of?
Yes, I've testified as an engineer and planner in numerous boards throughout northern New Jersey.
And how long have you been practicing for?
29 years.
Okay. I would submit Mr. DeSessa as an expert in the field of professional engineer, professional planner.
Okay, so he could testify as both or either engineer or planner.
Correct. I don't know that we're frankly going to need much professional engineering testimony since we're not really changing the site plan. He's really here this evening as a planner.
Okay.
But if there are any engineering questions, he could field them.
Do we have questions?
Excuse me?
I'm asking the board. Do we have any
Oh,
questions?
sorry.
No. Okay, so we will then recognize you an expert in both engineering and planning.
Thank you.
Thank you.
Mr. DeSessa, would you tell the board you were retained by Dr. Singla to assist in this application, correct?
That's correct.
And you had an opportunity to do some research into the application?
Yes.
And I believe you made some findings that you set forth in a report, is that correct?
That's correct.
And would you please explain to the board the nature of your findings and what your opinion is?
Okay, I prepared a report which was submitted with the application addressing mainly the requirements for the variance checklist and setting forth various information and proofs to substantiate the use variance that's being requested tonight. The property is located in the B1 zone. B1 zone permits professional offices, however, only on the second or higher floors. Therefore, placement of the professional offices on the first floor requires a use variance. Property is block 1906, lot 7, as you heard. It's on the northwest side of Valley between 1st and 2nd Streets. The aerial map on the easel here is basically just a blow-up of the one that was submitted in your packet, showing the site in question and also the surrounding uses identified with letters within 200 feet, and then identified on the next sheet what they were based on my field evaluation. The building's a 2-story building, as you know. It's currently vacant on the first floor. There is a tenant on the second floor. There are 8 paved parking spaces in the rear of the building. There's an ingress and egress drive on either side that's also paved. As far as the surrounding area goes, there is on-street parking on Valley on both sides of the street. There's 7 spaces on our side, or say the site side, and 8 spaces on the opposite side, as well as a large municipal parking lot directly to the rear of the subject property.
Sorry, I didn't mean to
Okay.
interrupt you.
No, if you had a question.
Yeah, before we do the surrounding area, I just wanted to get it on the record. With respect to the property in question, all of the bulk requirements except for the parking are satisfied, is that correct?
That's correct, based on the existing site conditions.
Okay. Anyway, go ahead, you can continue.
Okay. Just to familiarize the board, if you would, if you want to look at the overall aerial plan,
some of the uses directly adjacent to this use. Most of the uses are just business, commercial. There are several other professional offices located on the first floor, such as at 71 Valley Street, which is on the corner. And also, there's a lawyer office, law offices directly adjacent to this building, which has law offices on the first floor with, I think, apartments above that. Also on First, there's a lawyer's office that occupies the first and second floor on a building on that street. There, that block is basically B1. Across the street from the subject property, on the other side of that, that's actually your B2 zone. In that zone, the professional offices are permitted uses without a restriction as to the floor that they're on. They could be on first or second or higher floors. So in general, the uses surrounding the property or this use as a professional office in the building is consistent with that, and it's not atypical as far as there are other similar buildings that have that similar use on the first floor.
Now, you made reference to 71 Valley Street, correct?
Correct.
And you understand that's where Dr. Singler currently maintains his office on the first floor?
That's correct,
All right.
yes.
Is 71 Valley Street also in the B1 zone?
Yes, it is.
Okay. All right, you can continue.
As far as addressing the use variance requirements according to the municipal land use law, I feel the project site is particularly suited for this use. Mainly, it has an existing building there, so there's no new construction, no land disturbance. You have an existing building within the appropriate zone that could be used for this type of office use. It's easily accessible from the street for pedestrians and the traveling public. There's also on-site parking available. Now, in this case, that's an additional benefit here because many of the surrounding uses do not have that a combination of on-site parking. And I'll address the variance for parking, but it does provide a level of on-site parking, which is a benefit here. It's also surrounded by similar uses, so it's not a use that's going in the zone that's not common to that area. As far as the benefit to the community as a whole, the oral surgeon, the dental office is a healthcare type of use. I would generally consider that to be a benefit. Also, with the project proposal, with the work going on the exterior of the building, with updating the facade with brick and stucco, and also cleaning up the landscaping, that provides an additional benefit. And it's also an efficient use of that site. So for those reasons, I believe the board can find that that meets the positive criteria for the use variance.
I don't know if you said, before you continue with the other criteria, with respect to 71 Valley Street, other than Dr. Singler's office that's on the first floor, are there other professional offices also on the first floor of that building that you know of?
That I believe there are. I don't have that specifically outlined on the list. Let me just see that.
Dr. Singler's still under oath, right? Can I just call him back for a second just to clear up that point? I thought that Drew knew the answer to that.
Yes.
Dr. Singler, do you know the answer? Are there other professional offices on the first floor, 71?
There are, since I interact with those doctors all the time, there are two other doctors on 71 Valley on the first floor, along with myself.
Okay, thank you. Go ahead, Drew, you can continue. Sorry to interrupt.
As far as the negative criteria, we want to demonstrate that it will not be a substantial detriment to the public good. And in that vein, the use of the existing building represents an more efficient use of the site. There's no excessive traffic that we anticipate here. This is a permitted use. It's relatively low intensity type of use. It's going to promote a desirable visual environment in that it will improve the downtown area by improving the facade of the building over and above what it is today. And the particular use that we're talking about is an oral surgeon does not produce excessive amounts of noise. Although the lighting is not shielded, it's not such an intensity of lighting in a parking lot where you have a lot of glare coming up from this site. As far as the impairing the intent and purpose of your zone plan, the use is consistent with the surrounding uses. It's professional offices are permitted as far as the use itself, just not on that first floor. And it again becomes a use that can fill currently a vacant space and utilize an existing structure rather than disturbing and building a new structure for this use. Regarding the parking, yeah, your ordinance does require one space per 300 square feet of net area, which calculated out here to be 10 required parking spaces. The building has the 8 in the rear. Due to the site constraints and the particular size and development of the property as it exists, it's physically not possible to construct any more parking spaces on the site. They are maxed out. But due to the area it's located in, it has provisions for additional parking on the street. It has additional parking for the public on the rear. So in my opinion, those additional ability for additional parking in close proximity to the site would outweigh the negative of not having those 2 extra parking spaces. And as was testified, those spaces for the uses that will go in there will be adequate.
Let me ask you, did you have an opportunity to inspect this property?
Yes, I did.
All right, and were you there during the week or on the weekend?
I was there during the week.
Okay, and when you were there, did you notice that there was abundant parking in the area, or that there was any particular problems with parking
No,
in there?
I did not, and I think the photos that were submitted with my report, I tried to take a shot up and down the street, and this was mid-morning, about 10 o'clock. They were almost all available, and the spaces directly in front of the building were available. And though I did note some in and out, there certainly were not cars parked there the entire hour or so that I was around the site in the vicinity.
Do you have anything else, Mr. DeSessa?
That's all I have.
Okay. I have no further questions of Mr. DeSessa.
I have a question, Mr. DeSessa. Why do you think the town has the ordinance that says no professional office on the first floor in this zone? What's the purpose of that?
Yeah, I was trying to think of that actually, and I'm not 100% sure. The only thing I could think about is maybe this is geared toward a more a downtown area that caters to a lot of foot traffic, and that the uses on the first floor would be retail and more of where pedestrians can come in and out easily from the street, as opposed to uses that are less pedestrian, have a less of a pedestrian requirement and can be placed on the second floor, such as professional offices, which really don't just take off people from the general public. They usually have appointments or things of those natures, that nature.
Other questions?
Yeah, I have a couple.
Mr. Doan.
With regard to your parking calculation, you've based this on a building that's 3,200 square feet, and you just assumed a 90% gross to calculate your 10 spaces. My experience is that when you calculate the parking per hour ordinance, typically it'd be very unlikely that you'd only have 10% of the building that would be considered as not usable or common or not part of the net. So I know that part of the problem is that we don't have a firm plan for the first floor, but just for example, the second floor, if you deducted out the area of the stair or the bathroom and the common corridor, I think that would be more than 10% of that second floor. So in actuality, your estimate of the parking load relative to the net square footage might be on the high side. Would you agree?
I would agree, it's on the conservative side. I agree that if we went and subtracted those areas that the ordinance allows to be subtracted out, like the bathrooms, the corridors, even the demising walls, say, it would be likely more than 10% of the gross.
Okay. And you touched on this briefly, but the buildings on either side immediately, the restaurant, Papillon, and the liquor store that's associated with it, does that property have any on-site parking?
No, they do not.
Okay. And the properties immediately on the other side of the building, do they have any on-site parking?
No, they do not.
The other thing about this property, and this is sort of, I'm going to ask your opinion as a planner, do you see this building as being a building that would be attractive as a retail use, based on the fact that it's the only property on that side of the street that sits back off the street?
Yeah, I think it could be as a retail use. I can't, I mean, today's, people drive today more than they just walk, so I don't see any great prohibition of using it as retail. But I think the way retail is today, it's a whole different animal. It's a different, with larger stores and big parking lots and things like that, or you're looking at more of just a street with storefront type of retail. Here it's kind of mixed with what you have.
Well, but on your side of the street, you really do have the storefronts.
Yeah,
I mean,
mostly.
The restaurant, the liquor store on the other side are right on the property line.
Correct.
The buildings further down towards South Orange Avenue are right on the property line. This
Right.
one is really the only one that has a front yard.
Right, it's set back about 30 feet from there, yes. I mean, in that respect, it's not consistent with the storefront retail. That's correct.
No other questions?
Mr. Adler. Isn't there a grade to the parking lot from street level?
Yeah, it generally pitches down towards the rear.
What degree, do you know?
I think it's on the degree of maybe about 2 to 3%. It's not really that steep.
Do you know the level of the sidewalk and how many feet the back of the parking lot is compared to the level of the sidewalk?
I couldn't really tell you that because we didn't have a topographic survey done. If I had to just eyeball from my walking the site, I'd say there's about a 3-foot grade differential between the sidewalk and the back of the property.
Do you know when the restriction on professional offices in this zone on the first floor, do you know when that restriction came into being?
I do not know that.
So that if there were professional offices in some other buildings in the zone, those could have predated the restriction. Isn't that true?
That could be correct, yes.
So that the trustees, the governing body in South Orange could have decided at some point after those offices were there that it's not a good idea for them to be there. And that's why they put in this restriction.
I mean, that could be the reason. I don't see that immediately.
Do we know that for a fact, that that's the case?
I'm asking a question.
Oh, okay.
I'd have to look at, sometimes the ordinances will cite revisions dates, but that would require more research to see when those dates were, if it happened that way.
And did you see the 8 lights on or just off?
The building lights?
Yes.
Did not. I was there during the daytime, so they were off.
So you don't know what the intensity of those lights is? And you don't know where they cast their light?
No, all I could tell you is they are facing downward. They're the type of spotlights that can be adjusted, so they are facing at a downward angle, 45 or less towards the ground.
Okay. I have no other questions.
Okay. Do members of the public have any questions? No. I have a question for Dr. Singla. In our deliberations of this, if the board, in considering possibly granting this, would you consider screening the lighting or some shielding the lighting? Is that what would need to happen? Shielding the lighting?
By ordinance, it will need
has
to.
to be.
It has to be by ordinance?
Well, it has to
Well,
not
it-
spill more than.
It currently the ordinance currently requires light shields so that it doesn't
So
spill.
there's not, so then that's required. We don't need that as a condition of.
Well, right now, I mean, there's that.
There's existing lighting on the building.
Yeah, but they're changing I guess I was a little surprised you said to keep the lights because they're taking the current siding off and redoing the siding.
Right, so the new lighting would have to conform.
Okay, so
to
it's
the
presumed it would
ordinance.
conform.
I'm assuming it's going to be new lighting once you do the improvements to the exterior of the building, is that correct?
It would be a challenge to replace the facade without replacing the lighting.
Yeah, you'd be surprised. I've seen people take on that challenge.
Do we
But
need-
if
is there
there's
any-
going to be new lighting, it has to conform to the ordinance. And the same would go for the signage as well, because obviously the signage on the front of the building is non-conforming to the ordinance. And then the sign in the front, the ground sign, depending on what the applicant decides, if they're going to keep the ground sign that was previously approved for that location, it would have to be conforming to any prior approvals or the ordinance in that respect. Because they're not asking for any signage variances for this application.
Correct.
And there's no concerns about the garbage screening in back? There is.
I would,
Is that required also by ordinance?
Yes.
Does it show for a site plan to the planning board after this?
once you
if
have
we approved it?
jurisdiction, it's here.
So, okay, so we need to consider those things. Right.
Most commercial buildings.
I have a question for you, Ms. Scroll.
It's not a big deal.
So I know that the question was asked of the applicant's planner about whether or not, why it is that you're not allowed to have in this zone, while across the street you're allowed to have on the first floor professional office space. Is it mentioned in the town plan? What is the rationale behind that zoning difference? Is it to protect retail?
It's to make a pedestrian scale window shopping core and the B1 is considered to be the core of the downtown.
Which makes sense.
Which is when you have gaps, again, as their planner stated, I agree with what he said, that office tends not to be to reinforce a walking window shopping environment. But what the board, and I think we mentioned it in our memo, is that this is a bit unique because of the setback. And that tends not to be the case for downtown areas.
So that could be a reason to go away from the intent of the zoning in that area and the town plan, because a building setback 30 feet and
That
window
has to
shopping
be
isn't really conducive with a 30-foot setback. Right.
Sometimes there are plazas in front of, as we know.
But you'd give up landscaping then, right?
Excuse me?
You'd give up landscaping with a plaza.
Well, that it's, that can make it more an amenity. It all depends on, certainly, whether you believe that that's a special reason and that this site is particularly suited because of that configuration.
Well, thank you. It's very helpful.
Was there any summation that you were going to give, or?
Well, did you want my client to answer the question? I did have a chance to speak with him while you were talking, and he's certainly willing to take care of the lighting, screen it any way that's required by the ordinance, the signage we already addressed, and the garbage. We explained to him about the enclosure and what's required there, so he has no problem with any of that, right, Dr. Singh?
I mean, whatever the guidelines are, I have no problems following all the guidelines. So if that's what the contingencies or conditions are, I'm willing to follow them, whatever is appropriate.
Do we, if we were considering approving this, do we need to be concerned that everything isn't specified here? Is this something that we need to have done? You know, that he needs to come back here and say he's going to do this, that, and, you know, because it's kind of presented as a bifurcated.
We raised the issue of the garbage.
Yeah, I think.
That building was operational for all these years. How come, no one from the town, realized that, garbage had to be taken care of? As you said, you saw the pictures, the bags are just sitting there.
Well, this is our opportunity.
I know, but I'm just saying,
I also think, given the testimony that they're not going to change the doors or the windows, I guess the one thing we're giving up is a chance to comment on the specific design of the facade and the signage, and to try to guide that into a good place. But otherwise, I think the specification we could make now is you have to comply with the ordinance and the garbage and the lighting and fix the landscaping, right?
And you can make that a condition, obviously, of any approval.
Yes.
Well, certainly one of the options could be that, you approve the D variance and the C variance, if you're inclined to do that, subject to a submission of a minor site plan.
To be reviewed by Mr. Renda or
This
by
board.
this board?
But the applicant would be, oftentimes when an application is bifurcated, it's because they don't, and rightly so, don't want to spend the money if they're not sure that they will be getting the approval for the variances. So to the extent, if they are aware that they're getting an approval, certainly I would think the applicant has been more than accommodating, so it seems as though that isn't necessarily something that he would, I'm not speaking for the applicant, but...
Well, what would we get out of it? I understand that the technicality of come back with a final site plan, but it has to do with screening garbage, which is already required, shielding lights, which is already required.
Landscaping, those are things that you, even though they're required, you may have comments, which you do oftentimes, on applications, on site plan applications.
Yeah,
How is
right.
the screening going to happen? What is the landscaping? What is the lighting going to be?
We're giving up the opportunity to comment on the specifics
Correct.
of the solution, but they'll be required to solve the problems, right?
I would say it's probably unlikely that the planning board would approve a site plan application without having plans to look at, right?
Well, that's the point.
Right.
Is it possible I could make a suggestion? I don't know if your attorney's comfortable with this, but I know other boards have handled it. You could make it a condition of approval with an express requirement that he has to submit those plans ahead of time, not as a minor subdivision or a site plan, excuse me, but where your planner and engineer or whomever have to look at it and approve it, and if they don't, then he has to come back to the board. But if your professionals are comfortable that it satisfies the ordinance, I agree with the chairman that it's already things that are spelled out in the ordinance that he has to comply with. So I don't see the need for a minor site plan at this point.
Sal and I both would be uncomfortable with the extent of that kind of approval based upon us. It's really a board. It's not like there's a light fixture, and the light fixture would be approved. This is as much as it's minor, there are elements of that really are within the board's determination.
So the question is then, does this board think it's important enough for them, let's say we were to, essentially it becomes a bifurcated approval. And that's kind of what Dr. Singla did. Look, you should have come here with stuff specified. You really should have. This is kind of this neither here nor there. It's not exactly bifurcated, but we can't rely upon it. So if we can't rely upon it, it's kind of bifurcated. But is it that big a deal to the board? Maybe it's not that big a deal. We say, oh, it's minor stuff. You're going to take care of it. We don't need to come back with the
Well, I think we
site
have,
plan.
I mean, if it's true that the two of you are not comfortable with those, with the extent of the judgment, that you'd rather have the board do it, you should say that, and if that's the case, then I think that's,
Well, that's what they did say.
yeah, so that's a big deal.
Additionally, as the applicant moves forward with the design of the improvements, they may encounter things which, may drastically change the way things are, presented. The architectural plans that are presented are basically, are very basic, very generic. There isn't a lot of detail involved in these. As they start getting into the design, assuming the board is favorable in granting the use variance, the next step for the applicant would be getting into the design. In doing that, that's where some issues may pop up.
You would come back at some later date for that?
Well, that would be the opportunity for the applicant to come back and say, well, okay, well, I can't necessarily do exactly what the ordinance requires for,
But they'd have to come back at some later date.
right, and at which time they come back and they can present that at the same time. It's a minor application. It's not a new building. It's not a new parking lot. There's not a lot there, but there may be some issues.
Does it then require renoticing and filing a new application?
If it's a new application, it would require renotice, but if it's,
Would this just be
Could it be a
continued?
partial approval with a continuation?
or if they continue, or do it,
Well, when is he going to come back with it?
well, I mean, you'd have to talk to the applicant and see if,
From a design standpoint, we know that there's no major work to the outside of the building. The only place where there's gonna be some differences is on the inside, and which part he's gonna put his, put the chairs.
not necessarily. If they're doing a complete facade change, improvements to the facade, they're going to be changing the lighting. They're going to be doing the landscaping, which, we don't have a landscaping plan to take a look at. The garbage enclosure, the exact location of the garbage enclosure, the applicant's going to have to work with his engineer and see, okay, where is the logical place for this garbage enclosure? They're
But let's ask the client, Dr. Singh.
Yes.
When do you intend to get this thing going and moving?
It depends on the board in terms of when I would get the appropriate approvals to move forward. I really thought that the floor plan for inside the building was for informational purposes, so that way you have an idea of what the inside is going to look like, things like that. I didn't really think it was going to be, to give you an exact rendition of what the office will look like. If the wall moves 1 feet here or there, it's not going to make any difference to anybody in the board. In terms of the landscape will be better than what it is now, guaranteed. It's going to be my office, so it's going to be better than what it is now. In terms of the lighting is going to be whatever the ordinances require, and we're going to be submitting full construction plans, plumbing plans, electrical plans to get the appropriate permits to do this project. So I think, if not the board, but somebody at the Township of South Orange will have the opportunity to look at those plans and give us the permits to move forward, or not give us the permits to move forward and say, no, this is not in conformity with the ordinances and something needs to be changed. And then those changes will be so done.
Quite honestly, I don't, for things like lighting, I don't want to count on the building department, because it's an existing building. It could just easily say on the drawings, existing lighting to remain. And quite honestly, from a building code point of view, that's probably okay. So, I would want to have some good confidence that we have a specific light fixture specified with shielding so that we're meeting the code, that we know what we're getting, and that's on the approval drawings.
Let me ask a
So,
question.
And
if I can
it
just-
shouldn't be that difficult to do.
If I can just respond to that, why not then just put it a condition and say, this is contingent upon you having approved lighting by the board in order for this variance to be granted? I am not arguing what has been done in the past or what the requirements are. I'm here telling you that it's going to conform to that. And if the approval is contingent upon that, I'm willing to follow those contingencies. I'm not 100% convinced about having to come back. If you can put those as contingencies, I'm willing to follow them.
Well, it's not your call, though, really.
I understand.
Yeah,
I understand.
whether you come back. And in general, this is relatively minor, but we've been wise to avoid bifurcated applications because we know what we're getting. And in this case, it requires some trust. And you're an unknown quantity. You may be perfectly ethical and so on, but you may have, applicants miss things. And so generally, we like to make sure we know what we're getting for the final product.
Let me ask you, Doctor, when could you sit with your architect and have a plan ready architecturally that would represent the things that the board is looking for?
If I understand, the board is looking for the finalized floor plan for the inside of the building. They're looking for a landscape rendition of the outside, and they're looking for the specs on the outside lighting.
And the screening of the garbage.
And the screening of, and the screening of the garbage.
The garbage.
Essentially, the board is looking for, you have a survey that you provided.
That's correct.
And then there is a sketch in here that shows, approximately how the parking is laid out based on photo. The board would be looking for would actually be a site plan. Take the survey that's prepared now and have your engineer basically lay out, okay, this is exactly where the spaces will be, this is the circulation, this is where your garbage enclosure is going to be, and then any exterior improvements to the site. For instance, if the stairs in the back or something needs to be changed or an area needs to be blocked off or striped, no parking or anything like that, that would be shown on the plan. And then additionally, on that same plan would be the landscaping plan. As far as the architectural plans are concerned, you'd want to show the facade improvements, which is already started, on here, which has already been, placed on the plan. But show the lighting, where the lighting is going to go, and then on the survey plan, the site plan, from the specs, from the lighting that you're going to use, show the Isolux pattern that shows, exactly how the light is going to be shielded and blocked off. And that's basically the site plan that you're looking for. As far as the interior layouts, the architectural plans that are provided, those plans are not as critical to the board at this point because you are limited. The space is what it is. You're not proposing any additions or any changes like that. You still need adequate ingress and egress into the building, fire code issues, things like that. So what you have now may change somewhat, but it's not something I think the board is
Right.
concerned
I
with.
think we're really more interested in ingress, egress points and where the windows are.
Right.
I don't think we need a final floor plan.
My client thinks 2 weeks.
What you've submitted with regard to the floor plan and programming seems to be fine.
Okay.
This could be a very quick review then, couldn't it, for a next hearing?
If the applicant can submit the information, a minimum of 10 days prior to the next hearing, I suggest, do it as soon as possible. We can take a look at it and provide any comments or questions, and it could be easily addressed at the next meeting, I think.
And so we could put them on, it'd be reasonable to put them on first for the next meeting, potentially, right?
Yeah, but why can't we grant the approval pending he does these things?
Well, that's what we're talking about doing.
Yeah,
Exactly
let's
that.
grant the approval.
I guess we kind of jumped ahead of ourselves, though. The whole question, the basic approval, I think we're sounding like we're for it, but there should be some explicit discussion about impairment of the intent and the zoning plan, because that's what this is all about. If there's any objection, it would seem to be that this is in direct impairment of what the intent of the zoning plan is to create this retail walking space. And I think they acknowledge it. We've said it ourselves. And does anybody have any problem with that? I think what they stated, it's not the ideal retail space because it's away from the street. So it's not particularly inviting. This is the way I'm looking at it. And it's been vacant for several years. So I wonder what's going on there. It may not be so attractive as a retail space.
Well, I think that the thing that I've always thought about this property is that it's a very difficult retail property because of the fact that the building is set back 27 or 28 feet from the property line. If you drive down South Orange Avenue, the property has no visibility until you're directly in front of it. So from a retail point of view, I think it's a very hard sell. If you look at the properties to the Maplewood side, to the left side as you're looking at it, those are houses, the two properties are houses that have had additions added to the front to bring the building out to the property line. And for this property to function as retail, I think someone would have to do the same thing. They would have to build an addition to get the building out to to Valley Street. I think that this particular property, setback, and the only one on that street that has off-street parking, makes it an attractive use for office on the first floor. If it didn't have parking, I might be less likely to accept the change. But I think the fact that it's set back so far and it still has parking makes it a unique piece on this on this side of the street that I think I could accept the professional office on the first floor.
So could I. I don't really hear anybody objecting to that, so.
No comments? No, everything? Does that satisfy people down there?
I'm comfortable.
So then we're looking at, this is essentially a bifurcated application. We would approve the variances, the C and D variances, but pending a final site plan approval. Is that what we're doing here?
Can we do that? Patrick?
Well, I would think that if the plan is for him to return
You're getting the light.
for next week, if the plan is to return for next month, then it would make it cleaner
Just to do it then?
just to have one vote.
To just do one vote?
Right.
But what we're telling him, we're basically giving him a strong hint that we're looking at this favorably, and we want to make this happen.
Okay.
And he knows what he needs to do to make it happen. And if he comes back and gets it right, it can proceed very quickly at that point.
Okay.
So
I noticed on your agenda, the next meeting is November 7th, the Thursday night.
Yes.
We have to get everything in 10 days before, and then we'll be on the agenda?
Am I missing something, Ms. Gruhl?
No, the only thing that I'm also suggesting, and Pat, you would have to weigh in on this, that this could be carried.
Yes.
And therefore, there's no further note. Pat?
Yeah.
I was going to get to that, too.
Okay, that's what, I just want to
Yeah, there's no need for further
clear.
notice.
Right, so no further notice, we'll carry it, we'll give you an extension, whatever you need. And we'll see everyone on November 7th.
Yeah, and I'm going to put them first on because there's, not much debate that's going to go on here. And Fairview will be second.
Is that that's on Thursday, correct?
Yes, on Thursday.
That's the day.
Okay?
Why are we meeting on Thursday again?
I don't know why we're meeting on Thursday.
So the nice thing about this is that it'll force you to get all your other plans done quickly, so you can
Yes.
actually implement sooner than you would have had we just approved it today.
Okay, very
Exactly.
good.
You're
So
doing
we
them a
have a
favor.
plan. We'll see you next month.
Thank you very much, appreciate your time.
Okay, and with that, is there anything else? Okay, I'm going to adjourn the meeting. Thank you all.
The good thing might be fish.